Good morning and welcome to docket number 24-1201. The application of Yankee Gas Services Company doing business as Eversource Energy to amend its rate schedule. We are here today to start the evidentiary hearings in this matter. And we will begin this morning with administrative matters. I'll begin with any administrative matters from the company, please.
Thank you, Madam Chairman. Good morning to the commissioners. I have a few administrative matters to run through. First, the company has quite a large group of witnesses here today, and therefore, when we take the lunch breaks throughout this hearing, I would ask that we have as close to 45 minutes as feasible. The second item I have is that late filed Exhibit 1 has previously been established through motion number 69, which PURA granted on April 28th, 2025. The LFE1 exhibit provides the revised cost of service exhibits where needed to incorporate corrections identified throughout discovery, and that will also be updated for any other corrections identified through hearings. Yesterday, the company filed a updated witness list. That letter is in the record. If the authority needs me to run through those updates, I could do so now, whatever your preference is.
Perhaps when we get to the panels that are affected, we'll, at the start of each panel, ask for you to introduce your witness panel, so it will probably be picked up there.
Sure.
Thank you.
Sounds good. The next item is that yesterday we filed a procedural request related to the PBR and ROE panels. Those are the last two panels scheduled for this hearing. In reviewing the hearing agenda and the estimated cross-examination times, we noted that those two panels would be expected to appear on June 4th and 5th. And that creates some scheduling problems because the company's PBR witness is not available on June 5th. And then additionally, the OCC's ROE witnesses had availability constraints, and they are not available June 3rd, June 5th, or June 6th. So thinking through the potential scheduling conflicts, the company has proposed to flip the order of those two panels so that the PBR panel could potentially commence and conclude on June 4th based off of the estimated cross times. And then it's the company's desire to have all of the ROE panels to go together rather than potentially spread the ROE panels out across multiple days to accommodate the OCC's witness availability. The company is proposing to move all ROE or cost of capital panel appearances to Monday, June 9th, if that's acceptable to the authority. However, if there's other accommodations that the authority views as appropriate, the company is open to hearing those potential proposals. I think part of that consideration is that the company is very interested in hearing the testimony of both OCC's and EOE's cost of capital witnesses. And upon hearing that testimony, the company may wish to recall its cost of capital witnesses pursuant to PURA Regulation 16-1-39 and have an opportunity for any potential redirect that may be needed after those other parties' witnesses appear. So that's all that the company has for administrative matters.
Okay. I apologize. Let me just catch up. I was under the impression that the company parties and interveners had had the opportunity to weigh in on the preferred panel order and witness list. So it's just a bit of a surprise to me that we're discussing this at this late hour. Is that not true? The company did not have the ability to set the panel order?
Oh, The company proposed a panel order on March 24th, 2025, and specified specific dates that the company believed would allow for all witnesses to appear without any schedule modifications. However, in the authority's agenda, they did not adopt specific dates, and rather you've set a rolling hearing agenda. And of course, that has not taken into account the availability or blackout dates of any parties' witnesses.
Okay, I appreciate bringing that to the attention of the authority this morning. I'm not prepared to address that this morning. I think we can take that under advisement, and we'll see if the cross estimates hold, because that may make this question moot. So we can revisit it tomorrow after we've completed 2 days of hearings.
Thank you very much.
Thank you. I apologize, Attorney Tisler, is that the last?
Yes, that
Okay,
was
thank
the
you.
last administrative matter.
Thank you. Parties and interveners, if there are administrative matters, please approach the mic. Attorney McNorney.
Good morning, Allison McCorney for the Office of Consumer Counsel. Sorry, can everybody hear me? Okay. Okay, sorry. In response to the company's scheduling issues, our witness does have it would work better for our cost of capital witness if we were to do the ROE panel on June 9th. I wanted to throw that out there for the authority's consideration. As the authority is also aware, we did file a motion to adopt via affidavit for our depreciation witness. I just wanted to bring that to the authority's attention. And as far as scheduling today is concerned, I don't believe it will be an issue based on the cross estimates for today, but OCC's witnesses, Dr. Hopkins and Dr. De Leon, will not be, excuse me, present until tomorrow morning.
Doctor, I apologize.
That's, sorry, that's for the clean technology panel.
Okay, they're not here today. That's okay, thank you. Any other party or intervener? Director Lopez?
Good morning.
Thank you. Anyone else? All right, seeing none, is there any public comment this morning? I apologize. Let me just backtrack to the OCC's motion to adopt by affidavit. I believe we're still waiting to see if the EOE or the Office of Attorney General was going to weigh in on the motion. Attorney McCorney.
Yes, at this time, OCC has not heard back from either party. They did reserve the right only in the record, but I have not heard whether they plan to affirmatively cross that witness.
Okay, well, we will hold off on ruling on the motion. I think it's 2 days old. When is that panel scheduled, please? You know?
I don't know off the top of my head. I believe it is it's certainly not until next week. It's toward the end of the hearings.
Okay, if I can ask any party who has not weighed in on the motion by the OCC, you don't have to do it now unless you're prepared to, but if any party is going to take a position on the OCC's motion to adopt witness Dunkel's testimony by affidavit, I would ask that you do so by the close of business tomorrow, unless you're prepared to do so now.
Thank you.
Director Lopez.
EOE does not object to that proposition. Thank you.
Thank you. See the AG approaching.
Yes, Caroline McCormick on behalf of the Attorney General's office, and the Attorney General's office does not object.
Thank you. And I believe the company has already weighed in. Is that accurate?
That's correct. The company has no objection.
Okay, very good. Then we will endeavor to rule on that tomorrow. So appreciate that. I've already asked anything further. Is there any public comment? Okay, if not, then if we can begin by introducing the first panel, and then I will swear in those witnesses. Attorney Tisler.
Yes, one moment. Would the authority like to take appearances of the attorneys?
I believe I took appearances at the previous conference, but if there are any new attorneys that have not entered appearances since the pre-scheduling conference. No, I think we're all set. Thank you.
Okay, thank you very much. So first we have the overview panel. To the members of the panel, would each of you please state your full name and positions for the record?
Kevin J. Kelly, President, Gas Distribution Business for Eversource Energy Service Company.
And Douglas Horton, Vice President of Distribution Rates for Eversource Energy Service Company.
Thank you. If the witnesses could please raise your right hand, I'll administer the oath. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
Thank you. Attorney Tisler, please.
Mr. Kelly and Mr. Horton, as part of your preparation for this docket, did you provide pre-filed direct testimony and exhibits in this proceeding, which were marked as Exhibit YGS Overview -1 through Exhibit YGS Overview -5?
Yes.
Yes.
Did you also co-sponsor rebuttal testimony in this proceeding, which was marked as Exhibit YGS PBR Rebuttal -1?
Yes.
Yes.
Did each of you also sponsor responses to interrogatories submitted in this proceeding?
Yes.
Yes.
Do you have any corrections to your pre-filed testimonies or interrogatory responses not previously identified for the record in interrogatory responses?
No.
No.
Do you have any updates to your pre-filed testimonies or interrogatory responses?
Yes.
Mr. Kelly, your pre-filed direct testimony, Exhibit YGS Overview 1, stated that Yankee's current rates are insufficient to cover the cost of providing safe and reliable service to customers, including a fair return on the assets devoted to utility service. Is that still the case?
Yes. The change in base distribution rates have many factors. One in particular that is most important is the cost of capital projects since our last rate case in 2018. Also, the upward pressure of our internal labor expenses, material expenses, and other factors, including material since the pandemic. The cost of material has gone up and has caused upward pressure on the company. Cost of service increases due to revised state, federal regulations, as well as best practices that have been implemented since the Merrimack Valley incident in 2018. Also, pressure on the company around our recent downgrade in credit rating. The Standard & Poor's credit rating went down 2 notches from an A- to a BBB rating, which has caused pressure on the company in terms of borrowing, interest rates, debt, and equity capital. Our recent ROE quarterly filing was at 6.4% versus an authorized rate of 9.3%. And also an S&P noted that the average across the state of Connecticut for an ROE was 9.15%, I believe. So our recent quarterly filing at 6.46%, excuse me, is well below that.
Mr. Kelly, in your pre-filed direct testimony, YGS Overview 1, it references Yankee's proposed PBR plan. Why is the company continuing to seek PURA's approval of a PBR plan?
So in our view, we think the PBR is our best way to address the needs of the distribution system. It offers several benefits. It, one, holds the company accountable for performance metrics, as well as it brings stability to our customers in terms of rates, where they're not seeing a large increase in rates after several years of operating. It is something that we believe in, and again, more so for the fact that we are hopefully in agreement with Pura to enter into a PBR that, again, holds the company accountable, makes sure that we're operating and spending our money wisely, and making sure that we bring value to our customers. If not approved, that would, as I mentioned, cause the company to file for more rate cases over the period of time. The PBR ensures that the company will stay out of rate cases for 4 years, at minimum 4 years.
And what does the company seek as a reasonable outcome to this case?
Several factors that we hope to achieve here is the approval of the PBR plan, which I just spoke of, our distribution integrity management plan tracker. We hope to be able to continue with our investments, recovery of actual versus plant additions, reasonable increases in our O&M expenses due to the things that I've mentioned earlier with labor and material costs, reasonable ROE compared to other utilities across the state of Connecticut, a rate plan that enables the company to achieve our ROE if granted, recovery of deferred expenses, and also some guidance from Pura to our geothermal project that we suggested to in our rate case to help us and guide us in if that's something that Pura and the state of Connecticut is interested in. And then also we, in our rate case, we have provided a low income discount rate that we're looking for approval from Pura as well.
Okay, and is the company focused on affordability for its customers?
Yes, we are always focused on affordability, and we feel that, again, with the low-income discount rate and other services that we provide to the customers to help them and assist them, if we are able to achieve a rate increase, it is something as the president of the company that I'm always aware of and something that I'm always mindful of.
Okay, and Mr. Kelly, I just want to go back to the mention of the 9.15 ROE. Do you recall that S&P specifically pointed to recent decisions in which Pura ordered material base rate decreases reflecting reduced depreciation expense below average authorized returns of equity of 9.15% and significant reductions in pro forma rate base?
Yes,
And that was something that S&P had noted in its downgrade decision.
correct.
Thank you. Mr. Kelly and Mr. Horton, do you adopt your pre-filed testimonies and interrogatory responses as part of your sworn testimony in this proceeding?
Yes.
Yes,
Mr. Kelly, do you have an opening statement to provide Yankee's business and its rate case application?
yes. Just wait for the presentation to come up. Great, thank you. I just wanted to say thank you for the opportunity to present here. Just to go over the highlights of our case. Yankee Gas is the largest natural gas utility in the state of Connecticut. We roughly have about 252,000 customers. We serve 85 communities. Next slide, please. I'm sorry. Thank you. And our network comprises of about 3,500 miles of gas main throughout the state of Connecticut. And since 2018, in a program that I'll speak of quite a bit, we replaced 200 miles of leak-prone aged pipe across the state. Next slide, please. So the case overview. We have a base revenue deficiency of 203 million. Most of that, like I talked about, is around capital investments that we've made since 2018 around our leaking, aging infrastructure. We also suggested and proposed a performance-based rate-making plan that requires a stay-out commitment by the company, as well as we provide metrics to allow us to judge performance metrics to allow us to work with the state and ensure that we are performing to the highest ability that we can to bring value to our customers. We have a clean tech future of gas. I mentioned earlier that we were able to install a network geothermal system in Massachusetts. We are looking for guidance and work with the state of Connecticut if they're interested in a similar program with rate recovery mechanism. And also, like I mentioned, we have proposed a rate design to help low-income discount rate folks and consolidation of our customer assistance cost as well. So next slide, please. Quick breakdown from a pie chart perspective in terms of where the $203 million revenue deficiency comes from. As I mentioned, most of this is in infrastructure investments and upgrades, as well as the O&M pressures that we have, and then other small adjustments there. Next slide, please. So at Yankee, we're quite proud of the way that we operate, and we've implemented many things internally to prepare our workforce and certainly make sure that we provide a safe system to the public as well as our customers. We've implemented many best practices. One in particular is the Pipeline Safety Management System, PSMS, also referred to, and this was a federal requirement, API 1173. We were one of the first companies that implemented that prior to the Merrimack Valley incident. And we have certainly spent a lot of time investing in this system to ensure that we provide a safe and reliable service to our customers. With that pipeline safety management, we have separate groups that go out and audit our crews to make sure that they are performing to our standards. And many of our standards go above and beyond state and federal guidelines. We've performed enhanced leak surveys to ensure that our customers are safe. And certainly by doing that, we gain a lot of data on our system to make sure that we invest our dollars in the right places. We also have spent a lot of time and money in increasing the accuracy of our mapping and making sure that when our employees and the public are out working around our facilities, that we have accurate maps and records and we mark facilities so that we don't have damages. Next slide, please. So with that, and again, many of our crews and we have focused quite a bit on the integrity of our system with miles of replacement of main. Since 2018, we have replaced several miles, which has helped us decrease our emissions across the state of Connecticut, as well as we've reduced our leak-prone inventory considerably. And these are just some examples of work that has gone on in the last 5 or so years. Next slide, please. So just to kind of bring that in a little bit, in our distribution system, we have cast iron, bare steel, many old leak-prone pipe. This is pipe that was installed. Some of it could be over 100 years old. As we replaced that, we put in plastic pipe or coated steel pipe, that's state-of-the-art pipe that, again, lasts well over 100 years. So we take old infrastructure out, we replace it with new state-of-the-art infrastructure, and obviously that provides safer distribution for our customers, for our employees, and for the public. Next slide, please. We also invest quite a bit in our resiliency projects, and what that means, we look at our system, we constantly monitor our system, we look at supply deficiencies, we look at ways that we can make sure that in the event of an accident or in the event of a supply disruption, we are able to continue to supply safe and reliable service to our customers. And as many folks know, the incident that occurred on on Route 95 on southern part of Connecticut. There was a bridge fire, a tanker hit that bridge. We were in a position that we could have lost several hundred customers and had a several-day outage. We were able, because of our investments, able to take our systems, move gas around, because of the investments that we've made, we dual loop systems, and we were able to isolate that bridge and not lose any customers whatsoever. That has been our strategy in looking at the growth in Connecticut as well as large customers across Connecticut, and making sure that we invest in the right way so that they don't have disruptions, which obviously is very good for the economy, making sure that businesses in Connecticut have a solid supply of natural gas. We've also invested quite a bit of money in our infrastructure around the supply side. If you look at the picture to the right, that is a single fed regulator station. And this was one of the things in Merrimack Valley that was identified as a potential risk across the entire country around regulator stations and the supply. We have updated many of our regulator stations to dual run stations for more reliability, as well as on some regulated stations based on the configuration, we've installed overpressure protection as well. So again, investing in the right ways, making sure that we run a safe and reliable system. Next slide, please. As I mentioned, we've invested quite a bit of capital dollars on our resiliency programs, and looking across from our last rate case, we suggested that we spend X amount of dollars on resiliency projects over a period of time. We've made a lot of progress in this program. We've completed 74 miles of pipe out of 97 that we originally planned. So we do have more to go. And certainly, as the example that I mentioned on Route 95, those are the projects that I'm talking about, to be able to backbone the system, make sure that we supply reliable gas to our customers, and certainly look at things that happen in the world, whether it's hurricanes, natural events, fires, things like that. We're always constantly looking at our system and making good decisions and investments to avoid those disruptions to our customers in the future. The GPSU has also proposed safety regulations that will have an impact on the business, and our company has obviously participating in those, and we are always welcome to new safety regulations, and we are in agreement with those safety regulations moving forward. However, there is a cost to implement those safety regulations for the foreseeable future. They should be going into effect over the next couple of years, but before they do go into effect, we obviously do a lot of work planning. We need to make sure that we have the right resources to support those regulatory changes. But we anticipate roughly over the next 5 years, that'll be about $100 million worth of capital and roughly about $5 million in O&M cost with the new regulations in place. Next slide, please. So I talked quite a bit about our investment in replacing of leak-prone pipe. And if you really kind of think about our business, and me in particular, I'm responsible for the system and making sure that I can remove as much risk out of the system as possible. And replacing leak-prone pipe with state-of-the-art pipe is one of those ways of doing that. But it also has a great effect on reducing our overall leaks. As you can see, we have reduced our leaks quite a bit over the several years, and that has been a direct result from our replacement programs, as well as each leak you remove with new state-of-the-art pipe, you reduce your emissions. So we've had a nice downward trend in reducing our overall methane emissions as well. Next slide, please. We talked quite a bit about a network geothermal system. We're very proud of the system that we installed in Framingham, Massachusetts. We worked with the state of Massachusetts to bring a new idea to the state to reduce emissions and have clean energy. This is a one of a kind in the country. Again, very, very proud of that. We worked with all the customers with this project. We were able to install this. It has been up and running. We went through its first winter last year. We're continuing to grab data, and we'll continue to grab data through the summer months on the air conditioning side. But all in all, the project has been very, very successful, supported by our customers and the state of Massachusetts. So again, very proud of that project and certainly would love to work with the state of Connecticut to implement a similar project. Just very quickly, we are committed to this process. We feel that the company has a very good story to tell. We are investing dollars in the right way. We're always looking to make sure that we provide safe and reliable service to our customers. But as in terms of the case, we've attended 3 public hearings to talk to our customers, and certainly for me, I've gotten a lot of good input back from our customers, and they were well worth doing to hear what the community and our customers have to say. We've responded to over 1,300 inquiries, participated in 9-day on-site audit with Pure and OCC. So again, just we continue to want to cooperate. We continue to want to try to get to a settlement here that works for both the state of Connecticut and Yankee Gas Company, and we're committed to do that. Next slide, please. You'll hear from the panel. We have provided several documents around our capital investments. We have produced almost 97.7% of the documentation that was required. We went above and beyond. And again, I think it shows that our company invests in the right way. We have many controls around our spending, and we have documentation to hopefully prove that we are making prudent decisions in our investments with that. But again, just another example of, the way that we run our company and the cooperation that we have of producing that documentation. Next slide, please. So with all of this, there obviously is going to be an impact on our customers. And what we try to do here is make an example of the customer impact in the bill. And it is just an average bill that we're trying to kind of incorporate in to give folks a feeling for the impact that it will have. But approximately 38% increase net of the revenue and credit, of the average residential heating customer, and approximately about a $45 total bill increase if rates are approved November 1st, 2025. And just I'd highlight the caption or the bubble, if you will, from one of our customers, that they understand the investments that we're making. They understand, and they've seen many of our crews out there, and they certainly can understand the method behind the installation and the work that goes into that. But one of their concerns is the amount of impact that it has at one time. And again, that really goes back to how we're proposing this rate case to incorporate PBR so that we don't have that impact on our customers. But we certainly understand that. We would, it's something that we take to heart and certainly want to make sure that we work with our customers and work with Pure to try to lessen that impact going forward. And a PBR mechanism would be a good way to do that. Next slide, please. So I talked about the PBR, and we are proposing 7 metrics to look at. 2 of those are penalty only, and those would be the emergency response rates during normal hours and after hours. The other 5 are penalties plus incentives with total damages per 1,000 tickets, digital engagement, gas emergency calls, number of justified complaints per 10,000 customers, and methane emissions associated with grade 3 significant environmental impact leaks. So again, trying to hold the company accountable for performance and hopefully in a recovery mechanism that's in place that with increased rates, we obviously need to make sure that we perform well for not only Pure, but for our customers. Next slide, please. And as I mentioned, we understand there's an impact to the customer's bills. We have put a discount rate in this proceeding, and we also have other options for customers to reach out to the company, and we're always willing to work with the Connecticut Energy Assistance Program, matching payment program, flexible payment plans, and budget billing. So again, we're always looking to work with our customers to make sure that we provide them safe and reliable service, but we understand that is an impact on our customers and things that are happening across the world that are many, many pressures with interest rates, inflation, and other things. So we are certainly aware of that and always willing to work with our customers to help them pay their bills. That's all I have. Thank you very much. I appreciate the time.
Thank you, Mr. Kelly. Chairman Gillette, the panel is available for cross-examination.
Thank you, Attorney Tisler. Authority staff. Across. OCC. Okay, thank you.
Morning, Tom Wheel for the Office of Consumer Counsel. I just had a couple of questions about the direct testimony. First, there was some testimony about the S&P downgrade decision and the contents of the decision. Is that decision in the record anywhere? Are you aware?
If you give me one moment, I can try to search for it. I believe it will be in response to OCC 280, but I just need to load that response. Attorney Wheel, would you like me to track it down? I would say if it's not on the record, it's certainly something we'd be happy to produce. I do believe it is. I can track it down if we want to have me do that.
And I would also add the witness is allowed to speak as to their personal knowledge. So we can proceed with questions if Attorney Wheel wants to, in terms of the witness can testify as to their personal knowledge about the report.
Thank you, Attorney Pace.
Sure. I see there are 3 attachments to OCC 280, so I guess I just wanted to confirm the first attachment I'm looking at is a S&P Global Ratings document labeled Ratings Direct. It's labeled tear sheet. It says Yankee Gas Services Co. and it's dated June 17th, 2024. Is that
Okay. No, forgive me. That would not be it. I was reviewing based on the attachments. If you give me one moment.
I mean, if it's faster and the company doesn't mind the potential of having duplicate evidence in the record, we could just ask for it as a late file.
I'd be happy to do that.
Okay.
Okay, so late file exhibit 2 will be to provide a copy of the S&P.
The S&P downgrade decision that was referenced on direct.
Thank you.
We just want to note for the record that we think actually it may be available in QRRU 152, attachment 1. It's pages 1 through 45. It's entitled S&P Global Ratings, Eversource Energy Issuer Credit Rating Lowered to BBB from A-, stated December 9th, 2024.
Yeah, I can just ask, I'm looking at that attachment now. I can ask the panel to confirm, is that the document that was referenced on direct?
I'm sorry, what was the reference? RU 152?
Attachment 1.
Thank you.
That was dated December 9th, 2024.
Yes.
Okay, I will strike that late file.
Thank you. So my question is, there was discussion this morning about the content of that rating downgrade related to pure rate case decisions. There's a second bullet there that references the company's FFO to debt ratio. Is it your understanding that that was also a driver in the credit rating adjustment?
When you say a second bullet, you're referencing page
Page
2 of 45?
Page 1 of 45. The first bullet, as I understand it, references the PURA decision in the CNG SDG rate case, and the second bullet says additionally, Eversource's financial measures have remained weak for the current period, current rating, including funds from operations, FFO to debt of 11.1% for the 12 months ending September 2024.
That's what that says, correct.
Okay, so that, is it your understanding that was another reason for the downgrade in addition to the PURA rate case decision?
The primary reason for the downgrade, as referenced in that report and others, is the Connecticut regulatory environment. There were other factors that were referenced as well.
Okay. So when you say primary, like on page 2, it discusses rating action rationale, and there are two kind of paragraphs there. One is labeled, we revised downward our assessment of Connecticut's regulatory construct for Eversource's Connecticut utilities. And then the second one says our downgrade of Eversource also incorporated the company's weak historical financial performance. So how is it that, what's the basis of your analysis that it was primarily the first one?
Well, the downgrade was not just limited to any Eversource entity. Other Connecticut-based utilities were downgraded because of the Connecticut regulatory environment, which could not have been impacted by anything to do with Eversource affiliates. I also note that they've referenced first the Connecticut regulatory environment, and I think that speaks to the concern that the rating agencies have with the Connecticut regulatory environment. The regulatory environment is also a key factor in establishing the credit rating for any regulated utility. The regulatory environment is what determines the level of revenues that the utility is allowed to recover through rates authorized by the regulator. And so when a credit rating agency is evaluating the creditworthiness of a regulated entity, the regulatory environment is the primary factor that goes into that determination. Certainly, there are financial considerations as well. Those financial considerations are driven in large part by the regulatory outcomes, which is why it has such a heavy weighting in establishing the credit rating for each regulated entity.
Okay, thank you.
Welcome.
And the FFO to debt ratio that's referenced in the S&P document, are there factors other than the Connecticut regulatory environment that contribute to that ratio?
You're talking about for Eversource parent?
Yes.
Eversource parent company has regulated and unregulated entities, and the regulated entities operate in other states. So yes, there are other factors that contribute to the parent company's financial metrics that don't have any bearing or impact on Yankee Gas, for instance. Yankee Gas is a regulated entity that is subject to the jurisdiction of PURA, which again is why from a credit rating perspective, when evaluating the creditworthiness of a regulated entity, the regulatory environment is a a key concern, as is the legislative environment. That's also referenced in the prior paragraph where it references Senate Bill 7 as a negative, as negative for the credit quality, of utilities because it discontinued the use of electric system improvement charge in future rate proceedings, et cetera.
Okay. And it sounds like your testimony is that the downgrade specific to Yankee Gas Services, which is from to BBB from A minus, was not impacted by the FFO to debt ratio of the parent company?
My testimony is that the action taken by the credit rating agency was due to the Connecticut regulatory environment, the substantial material downgrade of the regulatory environment, and the assessment by the credit rating agencies that Connecticut is a poor regulatory environment for utilities. That is what prompted the rating agency's action. The rating agencies were monitoring the FFO to debt as being its primary metric in looking at the credit ratings. However, the action would not have been taken were it not for the continued demise of the Connecticut regulatory environment or decline of the Connecticut regulatory environment. We have been executing on a plan and continue to bring the financial metrics up to the standards that would have maintained the rating. And had it not been for the continued deterioration of the Connecticut regulatory environment, the rating agencies likely would not have taken action at the time as they did, and again, as they did for non-Eversource companies, which could not have been impacted by anything to do with Eversource.
Would you make the same speculation in a hypothetical where there was no FFO to debt ratio issue? Would this credit rating have resulted from only the Connecticut regulatory environment?
I'm going to object to the hypothetical, but if the witness is able to respond, he can do that, but I object to the use of a hypothetical.
I'm using the hypothetical in response to the witness's speculation of what would have happened absent the Connecticut regulatory environment. So I'm asking the reverse, what would have happened in the witness's opinion absent the issue of the FFO to debt ratio?
Overruled. Direct the witness to answer to the best of his ability, please.
Could you repeat the question?
Sure. The question was, your testimony is that in your opinion, absent the impact of the Connecticut regulatory environment, this downgrade wouldn't have happened. So the question is it your opinion that absent the impact of the FFO to debt ratio issue, that this downgrade nonetheless would have happened?
The regulatory environment, like I said, is the primary factor that goes in the credit rating agency's determination of a regulated company's credit rating. And so I wouldn't be at all surprised in this hypothetical that had our FFO to debt measures been better from the credit rating perspective, that the action still would have been taken. It was prompted on my expertise and opinion by the continued deterioration in repeated orders issued by PURA that, as viewed by credit rating agencies, is credit negative, objectively credit negative. And so that is a strong signal, again, as the key factor for a credit rating agency in determining the credit rating of a regulated utility in going into that rating.
Thanks. There was also testimony on direct. I think I heard testimony referencing the company's struggles to access capital currently. Is that correct?
I think the reference, and can defer to Mr. Kelly to elaborate, we're talking about the same concept that you are asking me questions here, which is that as a regulated utility, we are required to access capital all the time to serve our customers, capital that far exceeds the revenues that we collect in rates from our customers. So credit rating agencies who are assessing the credit worthiness for debt lenders, and then equity investors and analysts who monitor utilities, investor-owned utilities, have hold in very high regard the ability for that utility to recover its cost of service, including earning close to an authorized return on equity, a reasonable return on equity in light of the risks taken by, which are different for both debt lenders and equity investors. So when the debt lenders and equity investors that utilities rely upon to access capital to serve our customers evaluate that the regulatory environment is such that that recovery of and return on investment is in serious jeopardy, then that will cause there to be less attractiveness of the investment, causing upward pressure on the cost of that investment, if nothing else, and making it harder to attract the capital.
And has that occurred? Has it been harder to attract the capital?
Certainly, our cost of capital has increased as a result of the detriment of or deterioration of the regulatory environment.
Cost of debt capital?
Cost of all of our capital, debt and equity capital. The two are linked, and the cost of equity capital is, at this point, our cost of equity is higher than other utilities because of the Connecticut regulatory environment in the view by equity investors and debt lenders, or that the Connecticut regulatory environment is such that the ability to cover our costs and earn a reasonable return commensurate with the risk is inadequate. And so it's causing upward pressure. And that is why we have concerns and have continued to voice them from our customers' perspective, that the ramifications of the Connecticut regulatory environment being what it is will be long lasting for our customers. Upward pressure on our costs of doing business for years to come.
Thanks. So with respect to debt capital, what kind of increase in the cost of debt has Yankee seen as a result of the regulatory environment in Connecticut?
Well, anytime there is a downgrade in your credit rating, then the relative cost of debt will increase. And again, that cost of increase, that higher cost of debt, will sustain for the life of that debt until its maturity. And so that's where I say that the cost increase will persist until at least that debt matures. And that's why we continue to have the concerns that we have. Every debt issuance that we now have, unless and until the credit rating can be restored as a result of a reassessment of the regulatory environment, will now be at a higher cost than it would have otherwise been.
So the credit rating downgrade impacts the interest rate on the current debt issuances on the company's books? The company is currently paying a higher interest rate as a result of, on all of its debt issuances as a result of the credit downgrade?
Any debt that is issued now with the higher or the lower credit rating is now going to come at a higher cost than it would have had we maintained a higher credit rating. And that's my point, is I think, and I didn't mean to confuse matters, it isn't that when you get a downgrade or an upgrade that existing debt issuances are renegotiated or recast. The point is that because we now have this downgrade activity happened, I think it's indisputable that the cost of any debt issuance now that we've been downgraded will be higher than it would be had we not been downgraded. That higher cost will persist until that debt matures. Similarly, for an equity investor who's choosing where to invest their equity capital in evaluating the relative riskiness of Eversource operating significantly in the state of Connecticut, viewed as the worst regulatory environment in the country, will demand a higher return, a higher cost of equity than would an investor who is choosing to invest their capital in a regulatory environment that is perceived to be more supportive of the utility's ability to recover its costs.
Thanks. So my question was, has the company issued debt at a higher cost since the credit downgrade?
I would have to confirm our debt issuances for Yankee Gas Company, but my testimony is simply that any debt issuance that Yankee Gas undertakes or any of the Eversource companies who've been downgraded as a result of the factors we've mentioned will now be issuing debt at a higher cost than they would otherwise have it issued if we had maintained the higher credit rating.
Okay. The company's debt costs are included in the SFRs and in the D schedules, right?
That's right.
So if there were a higher cost of debt, that would include the historic test year costs and then any known and measurable adjustments, correct?
To the extent there was a known and measurable adjustment reflected in our cost of service, and that known and measurable adjustment was at the higher cost of debt, that portion for that debt issuance would reflect the higher cost. I think
I'm just asking, is there a known and measurable adjustment to the historic test year cost of debt to reflect the credit downgrade effect?
One moment, please. Subject to check, I don't believe we have incorporated a known and measurable change specifically related to the credit downgrade, as the credit downgrade happened after the filing of our petition. We didn't propose in our initial filing to reflect an adjustment targeted to that. We did propose in our initial filing and provided testimony on the regulatory risk premium that talks about everything I'm saying and the higher costs of the negative attributes of the Connecticut regulatory environment. That is described at length in our initial filing as a component of our requested and required return on equity. The cost of debt, as I said, would be impacted such that to the extent there's a known and measurable adjustment in all future rate applications that will be based on actual historical test year and outstanding debt at that time, the evaluation of the debt and the cost of that debt in any future proceeding, again, until the debt matures, will then reflect the higher costs having been downgraded and then issued at objectively a higher cost than had we not been downgraded.
Okay. But the testimony, as I understood it this morning, was that one of the drivers of the necessity for increased revenue in this case was the increased cost of debt, but there is no increased cost of debt passed on to ratepayers in this rate application?
I think our testimony in the direct in our case is describing the need for higher revenues to support our ongoing investments. We need to have revenues to support the investments. We've made significant investments, as my colleague, Mr. Kelly, described over the last several years that are in service to our customers. The fact that we've invested more in our system than we've collected through revenues is the main driver of the need for a revenue increase.
Okay. You also discussed the cost of equity. The equity capital you're referencing would be infused to Yankee from Eversource Energy. Is that correct?
That's right.
Has Eversource issued any shares recently in order to obtain equity capital to distribute to its operating companies?
I would have to confirm that.
Subject to check, in Eversource's May 2025 earnings call, did the company discuss a planned $1.2 billion equity issuance?
That does sound right.
Subject to check, has that plan been discussed in prior earnings calls?
So I think we have talked, and our equity investors on those earnings calls are certainly focused on the equity issuances and the equity needs for all utility investors, because again, all utility companies, because again, utilities rely upon equity investment in order to serve our customers. A significant portion of the earnings that are reflected in rates for Yankee and for our other regulated entities are reinvested back into the system. But to the extent we require additional capital beyond that which is provided from our ongoing operations, we need to fund that capital with debt and equity. So I know in every earnings call, there's a discussion, usually in our opening remarks by our CFO, about the equity needs of the company planned over the planning horizon, which is a 5-year horizon, and then also an update on our status as it relates to the equity issuances that have happened. I just don't have at my fingertips the specifics about what has been discussed and when.
Could the company file as a late file exhibit earnings call transcripts from the beginning of the test year to present?
We certainly can. I can just see if we have.
I tried to find them and I couldn't, but I could. There's, as Mr. Kelly mentioned, there's thousands of interrogatories, so it's entirely possible I missed them.
We certainly can.
What was the time period on that, please?
From the beginning of the test year to the most recent, which, as I understand it, is just earlier this month, May 2025. And that would be late.
About two.
Thank you. I'm going to try to keep track of them in this. The testimony this morning mentioned that in the company's view, the PBR proposal would prevent the necessity for more frequent rate cases. Is that correct?
That is correct.
Okay. So in the company's view, is the alternative to a multi-year rate plan like the one proposed would be like annual rate cases?
Our testimony says that we would expect, in the absence of approval of a performance-based rate-making plan, that we would be commencing essentially a rate case filing every 2 years.
Okay. In the presentation that was offered this morning, on the screen on page 2, there is a reference to a member of the public commenting that this should be dealt with on a yearly basis so that you can keep track of the projects that are going on. And there's an arrow in that presentation associating that statement with the PBR proposal. What's the relationship in the company's view between that statement and the PBR proposal?
Yeah, and we talked about this in our rebuttal testimony on the PBR proposal as well. Certainly, the public commenters, to be clear, didn't use PBR or talk about performance-based rate making directly. But as this quote references, and others did at the public comment hearing that at least I attended, talked about having a budget, having more modest rate changes over time, which is one of the benefits and values of a performance-based rate-making plan. So we're drawing the direct link because we don't expect our customers to come into those hearings, talking and advocating for performance-based rate-making, because it's just not something that normal people do. But we see a direct link between our proposal and PBR and what those customers were asking for, at least those that were speaking, as this quote does, to having things dealt with on a yearly basis instead of having such a large increase happening.
How does the PBR, and I can ask the PBR panel this, but how does the PBR proposal keep track of the projects on a yearly basis?
So the PBR proposal does a number of things. Our PBR proposal, if adopted, would provide for annual rate changes based on our costs as presented in this proceeding, and adjusted annually by an I minus X. We are voluntarily proposing to set that X factor equal to 0. The study would indicate that the X factor should be set at a negative 1.45% to negative 1.55%, which says that inflation or our annual cost change just at a base based on the industry growth in costs relative to general inflation is increasing at a greater rate than general inflation. So by setting the X factor under a PBR plan to 0, there's a voluntary consumer dividend that's built into the proposal, meaning a stretch factor to the customer's benefit. That's one way that rates would be tied to annual cost changes. We've also proposed in this proceeding to implement a K-bar and a DIMP tracker in order to support incremental capital necessary to support the system that is required above and beyond that which is what's provided under that application of the I minus X, where X is set to 0. As part of the K-bar filing and as part of that DIMP tracker proposal, there would be annual documentation to submit it to PURA and to other parties. The DIMP tracker for sure would have an annual review of capital project documentation. The K-bar, we have also discussed in our case that the K-bar we would be able to provide updates along the way to PURA and other stakeholders of actual plant additions that have been made so that progress can be tracked, that questions can be asked, and the projects can be reviewed. However, one of the things that we're looking to achieve with PBR for all stakeholders would be to avoid the necessary undertaking of an annual full prudency review or that which would be undertaken as part of a comprehensive rate case. And so it really would be up to PURA and other parties to the extent that we want that annual process to become more administratively burdensome for all parties. So that's how we see our proposal aligning very closely to what that public commenter had said in the public hearing.
Okay. The second comment that was referenced in Mr. Kelly's presentation, I think it was on page 13 of the presentation, referenced the 7-year gap between rate cases. In the company's last rate case, was there a multi-year rate plan allowed?
There was.
How many years was that?
I believe it was 3 years.
Okay. So what's different about the last multi-year rate plan that was allowed in the last rate case versus the multi-year rate plan proposed in this case that would alleviate that customer's concern about the gap between rate cases?
In the last rate case, the multi-year rate plan, as had been PURA's practice at that time, was to set rates based on a forecasted test year and multiple years of a forecast of a cost of service, such that the revenues were set to reflect essentially, a rate case outcome for rate year 1 in each of the 3 years. PURA, in its most recent decisions, has declined to implement any such thing, and instead has approved rates that reflect rates for one rate year. And so our view is that, again, one of the values of moving to PBR is we are able to do so, having rates that are designed to support our costs, but moving away from our understanding of PURA's a desire at this point. And there's also, of course, an ongoing PBR proceeding that we're all participating in that's looking at this very thing. How can we have rates set in a way that maintains the utilities incentive to control costs, which is a direct benefit to customers, but still provides adequate revenues so that we can continue to serve our customers. And so that's how we're, trying to be responsive to the system needs and our customers' needs first and foremost, and building a proposal around what we're understanding to be PURA's in the state of Connecticut's objectives by moving forward on a path for PBR. If we have PBR, if we have revenues that can support the company's requirements to make necessary investments to provide safe and reliable service for our customers, then we would have rates that change more modestly over time, tracking with our costs. That would then avoid a large increase in rates like what we're dealing with in this proceeding.
Okay, so is it the company's interpretation of that customer's comment that what was sought was just more frequent rate increases as opposed to more frequent rate cases where there's a comprehensive review of the revenue requirement?
So I think my view, and it's difficult because again, I don't say this to be negative to any average customer. I really appreciate all the customers that show up. I don't think an average customer thinks of things the way that I do in terms of how utility rates are set, and nor should I want them to. But my point in what I took away from that customer was we're looking at a large increase, and Mr. Kelly and I are certainly cognizant and aware that a large increase, especially at any point in time, would rather be avoidable by all customers as it would be by us. But at this point in time, we know that customers are facing tremendous hurdles in their everyday life for things that aren't as critical or essential, but still necessary, and it's causing upward pressure on the cost of living for everything. And so in hearing those comments, I think it reinforced for us, again, what I'm saying, which is that I'd love it if we could get to a place here where we have a rate-setting paradigm that has rates that track with our costs, while still has full accountability for Eversource and its management and its employees to be reducing our costs for our customers so that the pace and rate of change in our overall cost of service is controlled, which is a customer benefit. So that's why we're viewing PBR as being better than an alternative one-year rate case outcomes, which the credit rating agencies acknowledge and we see as being credit negative, because a one-year rate plan in a time of rising costs, which for us is indisputable. We know that costs are going to go up as system needs increase, as our costs increase. And an alternative that requires a full rate case where all costs of service are updated on a every 2-year basis or as frequently as we would need to under a rate case outcome that provides no or very limited acknowledgement of the actual cost pressures of the utility, will result in greater cost increases for customers, more choppy cost increases for our customers than the alternative that we have proposed, which is a performance-based rate-making outcome that would have more modest changes over time, while still retaining all of the incentives for us to control our costs to the great extent possible.
Thanks. My last question before turning it to the Consumer Council, in Mr. Kelly's direct testimony, I think I heard a statement that was something to the effect of the company being committed to getting to a settlement. Can you explain what was meant by that?
So I'll take that one. All I meant by that is this proceeding, we're hoping that we have a favorable outcome for the company, PURA, and for our customers.
Okay. Thank you. That was my last question. I'll turn it over to Consumer Council.
Good morning, Claire Coleman, Consumer Council. Good morning to the commission and to Mr. Kelly and Mr. Horton. I just have a couple follow-up questions on your presentation this morning, specifically with regard to the company taking affordability into mind in its application before the authority. Would you agree that this is the largest increase in delivery rates ever proposed by a gas distribution company in state history in Connecticut?
I would have to research that to give you an answer.
Okay, so, well, with respect to Yankee Gas, is this the largest increase that Yankee has ever asked for in a state application?
So I became president in July of last year. I would again have to research the history of Yankee in terms of the increases to give you an accurate answer.
Okay, thanks. I'll take you up on that. Could I request a late file exhibit answering both whether this is the largest increase in delivery rates ever proposed by any gas distribution company in Connecticut, and whether this is the largest increase that Yankee specifically has asked for in a rate application before the authority?
And that will be late file exhibit 3.
Thank you. And are you able to confirm, is it accurate that Yankee is seeking an increase of residential rates that will impact customer bills by about a 43% increase?
Just one moment, please. So I know I'm looking at Yankee Gas Exhibit YGS Overview 1, page 13, excuse me. And that did show for residential heating customers, based on the initial filing, there was a proposed class increase of 43%. We also have, and so that will have adjusted slightly through the course of the proceeding as the deficiency has adjusted in late filed 1. But there's a PGM, excuse me, a non-firm margin credit offset that would reduce that, so that the increase on a residential heating customer basis would be, based on the initial filing, approximately 38.3%.
I'm sorry, did you say 38.3?
Yes,
Thank you.
you're welcome.
So, Mr. Kelly, even if the rate increase was reduced from 43% to 38, do you believe customers have the willingness and ability to absorb such a substantial increase?
So I can't speak for individual customers in terms of whether they can absorb that. All I can tell you is we understand that it is an impact on our customers. We take that very serious. However, I go back to my testimony in saying that we've invested several millions of dollars over the course of since 2018, as well as the company has had upward pressure on labor, material, and other factors increasing our cost to serve. And again, based on what Mr. Horton talked about with PBR, we are trying our best to look at this in a different way, to not impact customers all at once like this increase, and look at more of a year-over-year increase so that it's not as impactful to the customers.
Thank you. I have no further questions.
And
Thank
that
you.
concludes OCC's cross for this panel. Thank you.
Thank you.
Thank you.
Thank you. EOE. Thank you. Attorney General. Thank you. Commissioner Karen?
No question.
Thank you. Apologies, I just don't know if Commissioner Conti has questions. I wanted to. Okay. I don't have any questions. So does the company need a moment to consider redirect?
Yes, we'd like a moment, please, to confer with our witnesses outside the hearing room. Thank you, Chairman.
Thank you. Attorney Chase?
Chairman, thank you for the chance to consult. We do have just a few brief questions on redirect for Mr. Horton. Mr. Horton, do you recall the question you received from Consumer Counsel Coleman that inquired about the comparison of today's rate case compared to historical rate cases?
Yes,
And the companies agreed to provide a late file with that information?
yes.
Is there anything you'd like to add in response to that question at this time?
Just briefly, and we will certainly do the research and present the results of that research. I think the key point that we're trying to make is that we acknowledge that whether it's 43% or 38.5% or whatever the percentage ultimately is, we do acknowledge that it's certainly as proposed, it is a large increase. And any increase is difficult for our customers to bear. And that's why we have the proposals that we have in this case, namely that we are hoping to have approved a performance-based rate-making plan that we believe, and I do certainly at my core, will result in a more favorable outcome for our customers and avoid large rate case or large rate increases that come with full rate cases where all costs of service are updated. We also know that it's important that our customers not only care about the rates that they're charged, of course they do, they also care about the service that they're provided. And the fact is that the costs that we're presenting in this proceeding and the revenue deficiency that we have is driven by the investments that we've made in the system that are serving our customers well. And that's also why we have proposed, though, several proposals in this plan, which I know we'll get into later today, that are designed to meet our customers where they are, acknowledging that many of our customers are struggling to pay their utility bills, and programs such as our low-income discount rate proposal and others in this proceeding are essential to be able to ensure that our customers who are most in need are able to afford the services, the critical services that we provide. And so we just wanted to emphasize those points, acknowledging that any rate increase is difficult for our customers to bear and for us to propose, but that's at the essence of our proposals in this proceeding.
Thank you. I have no more questions for redirect examination.
Thank you. This panel is excused until the late file hearing. We'll move into the customer service panel, and I'd ask the company which witnesses to approach and for the authority staff to approach as well. Attorney Tisler, if you could please introduce your witness panel.
Yes, thank you, Madam Chairman. I would just like to note that Seamus O'Brien, Director of Voice of the Customer and Customer Experience Strategy, is joining this panel. Additionally, at this time, I would like to have the Revenue Requirements team members, Marissa Peruta, Michael Shelnitz, and Garrett Murray, sworn in case their testimony is required as part of this panel.
Okay.
So to the panel members, would each of you please state your full names and positions for the record?
I am Jared Lawrence, Senior Vice President of Customer Operations and Digital Strategy and Chief Customer Officer for Eversource Energy Service Company.
Good morning. My name is Tim McGrath. I'm the Director of the Contact Center for the Eversource Energy Company.
Morning, I'm Bernie Budgeon. I'm the Manager for the Credit Contact Center Vendor Management.
Good morning, I'm Dan Trainer. I'm the Director of Collections and Assistance Programs for Eversource Energy Service Company.
Good morning, I'm Jess Kane and I'm Vice President of Customer Operations and Assistance Programs for Eversource.
We have some additional panel members that are sitting in the rear. Could each of you please introduce yourselves?
Good morning, I'm Ashley Canali, Manager of Operational Execution of Major Projects for the Contact Centers for Eversource Energy Service Company. Thank you.
Seamus O'Brien, Director of our Voice of the Customer and Customer Experience Strategy.
Good morning, I'm Dave Coco. I'm our IT Director of Business Solutions for the Eversource Energy Service Company.
Chris Kishimoto, the Manager of Payments, Print, Vendor Management, Energy, Eversource Energy Service.
Michael Dooley, I am Director of Billing Payments Meter Data Services.
Thank you. Would the members of the Revenue Requirements team that will be sworn in also state their full names and positions for the record?
Yes, good morning. My name is Marissa Peruta and I'm the Director of Revenue Requirements for Yankee Gas.
My name is Michael Shelnitz. I am Manager of Revenue Requirements for Connecticut, here for Yankee Gas.
Good morning, Garrett Murray, Manager of Connecticut Revenue Requirements here on behalf of Yankee Gas.
Okay, could each of the identified witnesses please raise your right hand? I'll administer the oath. At the conclusion of the oath, please affirm by stating I do. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury. Thank you. Attorney Tisler, please.
Mr. Lawrence and Ms. Kane, as part of your preparation for this docket, did you provide pre-filed direct testimony, which was marked as Exhibit YGS Customer 1?
Yes.
Yes.
Mr. Lawrence, did you also jointly provide pre-filed direct testimony, which was marked as Exhibit YGS Metrics 1, and joint rebuttal testimony, which was marked as Exhibit YGS PBR Rebuttal 1?
Yes.
Ms. Kane, did you also jointly provide rebuttal testimony, which was marked as Exhibit YGS Rates Rebuttal 1?
Yes.
Ms. Peruta, Mr. Shelnitz, and Mr. Murray, as part of your preparation for this docket, did each of you provide pre-filed direct and rebuttal testimony and exhibits in this proceeding, which were marked as Exhibits YGS Rev Rec 1 through YGS Rev Rec 14, and Exhibits YGS Rev Rec Rebuttal 1 through YGS Rev Rec Rebuttal 3?
Yes.
To the entire panel, did you each sponsor responses to interrogatories submitted in this proceeding?
Yes.
Do you have any updates or corrections to your pre-filed testimonies or interrogatory responses not previously identified for the record in interrogatory responses?
No.
Nope.
Do you adopt your pre-filed testimonies and interrogatory responses as part of your sworn testimony in this proceeding?
Yep.
Thank you. The panel is available for cross-examination.
Thank you, Attorney Tisler. We'll begin cross of this panel by the authority staff. Attorney Church, please.
Good morning. I'm Victoria Church, up here as staff attorney. Beginning with the company's response to CAE 11, the company states in this response that internal customer support representatives, or CSRs, will transfer calls to a third-party call center when they receive a call that should have first gone to that external CSR. Can you confirm to me that the only types of calls where this transfer would occur are for credit and sales calls, sales collection calls?
I will answer that question. Yes, the only time where internal Eversource CSR would transfer a customer to a third-party CSR would be in the event that it was a credit and collections phone call.
Thank you. Can the company explain why this is a company practice rather than allowing the internal CSR to complete the call?
Certainly. So it is our belief that our third-party credit and collections vendor, Alorica, we have worked with them over the last 5 years and really since they've been part of our partnership to handle credit and collections calls, and they are best suited to handle those calls. And that is why we transfer those calls to our third-party vendor.
What is it that makes them best suited?
That is generally speaking, their primary focus, which is to handle credit and collections calls. Our internal CSRs handle every other call type. So billing call, high billing call, gas emergency, all of those gamuts, they handle all of that. And we have partnered with this vendor for credit and collections for the company-wide, I subject to check. I don't want to, at least since 2010, I believe, but I will check that. And they have handled all of our internal credit collections calls.
Do your internal CSRs not have training on credit collections calls?
We provide them training related to programs and protections for awareness. But if the customer says that they're having a hard time paying their bill or they need assistance, they are trained to transfer those calls.
So would they provide the customer for the names of those programs, for instance, you said they have that training for awareness, or would they simply transfer the customer out?
Subject to check, they are aware of the names of the programs. Whether they mention it, I can't answer affirmatively or negatively, but they would certainly ensure that call gets to the right place.
I do want to add to that too, is our credit and collection vendor, they have the expertise, not only in standpoint of the tenure they've spent with us.
I apologize for interrupting. Can you just check your mic? I can't quite hear you.
Can you hear me now?
Thank you.
All right, sorry. So, our credit and collection vendor, Alorica, they have the experience not only in terms of the tenure that they've spent with us, but also they bring in their past experience of managing other utility clients, what they have. So they bring in that expertise. And in the last 5 years, with all the orders that's come through, we have a very specific training which follows the PURA guidelines and call flow that our credit contact center vendor, they have instilled in training, whether it's new hire or it's quarterly refresher training. So they know the details and the nuances involved in that. Now, the internal contact center CSRs, if they are mentioning the names of those programs, it might open up a dialogue which they're not comfortable answering or they're not trained to. They might provide incorrect information. So our expertise, the subject matter expert, they handle those that information. That's why those transfers are sent to our third-party vendor.
If the internal CSR transfers the call to the external or third-party CSR, and the customers end up actually having questions that are only internal questions because they're so segmented, do they then get passed back and forth between external and internal?
No, so our CSRs are trained to ask if there's anything else they can help with. Therefore, with the intention that they should be able to assist the customer for anything that they need that would not be credit and collections related before it gets transferred back over.
And are your customers always clear on whether or not their issue is a credit and collections issue?
Yes, because most of the customers that call in our credit contact center, they have, and we do a compliance filing every month on that. 90%, higher 90% of the customers, they call about bill assistance, about payment arrangements, about them being behind on their payment arrangements or anything. So 99, 95, that range of customers are credit contact center. The credit contact center handles all customers that have an arrearage, and majority of the times they are handled within the credit contact center, and they don't need to go back and forth on that. And if it is a situation like that, we do have warm transfer so that we don't do just toggle between both the contact centers on that. So we take care of that as well.
Has the company considered providing the internal CSRs with that same training that Alorica CSRs receive?
I think my mic's on, sorry. It is something, so to answer your question, Attorney Church, we have provided our Alorica CSRs with some basic training around high bills and things of that nature for Yankee Gas. Confirm, correct?
Yeah.
Yeah, okay. Thank you. I want to confirm that's correct. It's something that we might consider in the future. The other point that I want to make, though, with using a third-party vendor, they have the ability to staff up reasonably quickly, comparatively speaking. So when we anticipate receiving calls as the moratorium gets lifted, and things that they can staff up and staff down more quickly than we can internally.
I'm sorry, I think my question was about providing the training that Alorica CSRs currently have to your internal rather than the other way.
Yes, no, I tried to answer that a little bit obliquely.
Right.
Sorry about that. We did it the inverse way. It is something that we have talked about. It's not something that we are exploring at the moment, but it is something that we look at regularly as we are looking at how best to serve our customers.
If I could supplement that, just for a question, probably because we know you just finished as well the Avant-Grid rate cases, but in the industry, it is a best practice to use a third party for collections calls, period, because of the seasonality. Right, the beginning of the winter moratorium and the end of the winter moratorium, and you don't internally, if you handled those same calls, you don't want to hire and fire people because the work isn't there. So that is an industry best practice. Unique to Connecticut is Connecticut prescribed a script that all CSRs have to go through. It is very difficult to be able to perfect, and no CSR will know everything. So you can't have a single human CSR who knows everything about solar and suppliers and low income discount rates and the matching payment program. So for that reason, all contact centers, and Tim and Bernie know this very, very well, you have expertise areas for the deep functional tangly topics, because there's no way anybody could know all of it. So it is the industry best practice and very much the norm as well. And Avant-Grid, I believe, just selected the vendor that we use and have been for years, which is Alorica, and they've been doing fantastic with compliance with Pura's script.
And just to add to Ms. Kane's, from a customer service standpoint as well, it's good to have compartmentalized focus on the customers with the CSRs, with the tunnel vision of focusing on the script, because there is a variety of information that a credit contact center CSR, that's Alorica, they have to follow through the script. Not only from a compliance standpoint, but all the information that needs to be shared with the customer. And giving that information with a specific subject matter expert, that becomes important as compared to being answered by one CSR knowing everything on that, because that is going to give more opportunity of error, if you might say that, instead of somebody who's an expert to handle that specific call type.
Ms. Kane, I think you mentioned that not everyone can be an expert in every area. When you get customer calls with these very specific questions that require a CSR with more expertise, how does that get pushed to that CSR versus a CSR who may not have that knowledge?
And I'll defer to my colleagues on this one, but I do know it related to the script. I know Bernie can talk specifically about that one, because the script, how we refer to it, is that's probably one of the hardest parts, because it's such strict compliance required for it.
So just so that I understand your question, you're saying that how come a customer is diverted to Alorica, the credit contact center?
No, my question is when we get into, I believe you called them squirrely areas, such as solar or any of the more specific programs that every one of your CSRs internally might not have the greatest amount of knowledge on. How is it that a customer would get from the CSR they reach first to a CSR with that advanced knowledge? How is that escalated?
So, so I'll start from the beginning. So when the customer comes in, say, for example, to a credit contact center and everything is kind of taken care of, but they have a question about, solar. With our new, and keep me honest on this, with our new telephony system, we do have specific skills that we can transfer to. So there are CSRs that are, say, for example, for solar, they are expert on that. So the CSR from their soft phone can select the drop down, which goes to that specific area where the CSR is 5, 10, 20, whatever that number is. They're skilled to answer those calls. So the customer doesn't go from, one department to the other. So that's a very direct transfer, if that answers your question.
Thank you.
Thank you.
In CAE 13, the company states that its contract with Alorica includes a provision for things such as penalties when appropriate. Can you explain for me under what circumstance the company would assess a penalty and what the penalty would be?
So the penalties and the incentives with the vendor is assessed based on what the contractual agreement has been. So I'll give you a twofold answer on that. In the past, we've had agreement with the vendor on certain metrics that they have to perform. Its quality, we used to have sales survey, hours delivered, which is number of people that we need, errors. So if they are meeting those targets and exceeding those targets, then they will get the incentives. If they don't meet those targets, then on a monthly basis, penalties are assessed to them. The second part of the question is that I want to answer is that we have, over the years, understood what the requirement should be to provide better experience to our customers. We have worked very closely with our vendor, and we have had discussions, and we're almost there with them on a performance-based rate contract, which has more metrics, which are more valuable to our performance, where we can get more out of the vendor. And it's a tiered-based performance metrics, basically. So you perform well, we incentivize you. If you don't meet those metrics, whether it's the base or lower than that, then we penalize you on that, and that's measured on a monthly basis.
And if I may expand a little bit on what Mr. Bajan was talking about regarding the performance-based contract, which we are almost in the process of completing. So there are 9 metrics that are weighted through a weighted average, and if our third-party vendor performs very well, they'll be paid higher, but that will have a benefit to the company. It will be ultimately beneficial for customers. And in the event that they do not perform well, they get paid a lower hourly rate. And that is how we call it PBR, performance-based rates. So they have these 9 metrics, and based on how they perform, as Mr. Bajan said, it's a 5-tier system. They have a base rate, they can earn above it, or they can earn below it based on their performance.
Can you explain to me how the increased payments to Alorica would benefit Connecticut customers?
Certainly, absolutely. And Mr. Bajan, please keep me honest here. So, for example, if their average handle time is lower, right? If we work to build efficiencies into what we call discretionary average handle time, hold time, after call work, things of that ultimately over time translates into fewer required FTEs, which would go towards customer rates.
So if I could add to that, I'm sorry. Just add to that, the performance-based metrics are designed or are calibrated in such a way that the efficiency that is derived from them and the improved customer experience that customers enjoy more than compensates for any increase in the rate that Alorica would receive.
So you say they're designed that way. Can you explain what you mean by designed that way?
Yep, and so I'll defer to my colleagues on the specifics there, but for example, transfer rate has a certain amount of unproductive time on the phone. If Alorica improves from that perspective, then we're paying them less non-productive time engaging with customers. Another one has to do with non-talk time, and I know that there are official terms for that in the contract that I'll defer to them. But essentially, these are things that that essentially Alorica would get paid for under the contract, but if they reduce their ratio of non-productive talk time with the customer, non-productive time that they're being paid for, then our overall remittances to them go down, even as their profits, so to speak, potentially go up. And anything you want to add?
So I think I understand your question, what you're looking for. What's the benefit, the end benefit to our customers? So the payments to, and I'll try and explain it to you with an example. So the invoices that we pay to the vendor, it's predominantly, it's all boils down to how many number of people they need to serve the calls that come in on that. Now, the metrics that we've devised or we've come up with is all aimed at ensuring that we are efficiently serving the customers, basically. And it all comes down to requirement of number of FTEs on the phone to answer that. If they're bringing that efficiency, say, for example, they need 100 people to answer 100 calls. Now, if they're bringing the efficiency, we have quality assurance, we have transfer rates, after call work, hold, all those things, basically. If they are bringing efficiency, they're charging us a higher amount. What happens is that because of less time required, because the transfers are less, after call work, hold time is less, the number of FTEs to now answer 100 calls becomes 90 FTEs. So there's a saving of 10. Yes, they do a higher rate, but it's lower money that is being paid from Eversource to the vendor.
Okay, so what is the scale of these changes in, let's say we've reduced one full-time employee and we improve, therefore, what is the scale of the increase versus the decrease?
So it's a weighted average for all 9 metrics. So it's not just that they improved, they get a higher rate just because they improved on one metric. They will get paid based on all the 9 metrics individually, basically, and that's going to be a weighted average. There's a percentage which is aligned to each of the metric, which will then eventually decide on the final rate, basically. And let's say, for example, the base rate is $30 an hour. If they are overperforming on 5 out of the 9 metrics, then they will probably get like $31. So that's like a $1 increase, whatever that percentage is going to be. And then if they're outperforming and meeting all the top tiers for all those metrics, they're going to have a higher rate, but then the FTE requirement is going to go down considerably on that.
And how are you setting the baselines for whether somebody is overperforming or underperforming? Or for the company as a whole, I suppose, not an individual.
So we've looked at the historical data that we've seen Alorica perform on. And based on that, we've devised our targets, the tiers, basically.
And based on that historical data, how do you consider Alorica is performing now?
Well, they're meeting the metrics as of now on the new benchmark. But there are certain areas that they still need to be, meeting the top tier. They're, a little above our base rate percentage. I'll have to go back and look at, specifically for the last 3 or 4 months, but they're doing good, not like at the top-notch level.
And I would also just like to add, if I may, that we have a clause built into the contract that we review the metrics every 6 months with the ability to adjust them. So for example, if they start to perform above the baseline or at the top tier, then that becomes the baseline so that it's a constant escalating performance upwards and not just staying at the baseline and that's it, if that makes sense.
It does make sense. As you change the baseline, however, does the pay also change? So if you've improved to the baseline and you're getting that additional 31 and you're now all at that improved rate, do we start at 31 and go up from there? Or do we go back to the base rate and add improvements again?
So subject to Mr. Bajan's check, it does not.
Does not what?
Sorry. The base pay does not change. So the target to achieve the base changes, but the base pay does not change. Validate, that's correct?
Yes.
Not sure if that was clear or not. I can try to make it clear if necessary.
I think it's fine, thank you. Does the company incentivize or penalize Alorica either currently or under this new contract based on the accuracy of call content? In other words, that the CSRs are providing customers with correct information? Is that one of your metrics, or is the thing we've mainly talked today about is sort of speed? And so I'm wondering about the accuracy and content.
Yeah, so quality assurance is absolutely one of the metrics that is on there. And that is one that they could be either incented or penalized on. So yes.
When do you expect the new performance contract to be completed?
I would need to confer with our colleagues in procurement. It is in their hands, but I would expect very, very shortly.
Approximately the next few months?
I would hope sooner than that, actually.
Thank you. And you mentioned that there were 9 metrics. Are you able to provide those 9 metrics under the new contract?
Yes, we absolutely can.
Are you able to provide those
sorry.
now or as an LFE?
Yeah, we can provide that. So one is the after-call work, the CSR hold time, transfer rate, quality assurance, hours delivery. Then we have feedback manager survey that we have. And then there's a silent time and working rate.
All right. In OCC 5, attachment 1, the company's attachment in our 2024 tab, the average speed of answers for credit and collections calls appears to be higher than average in late January, February, and March of 2024. Specifically, I think it's lines 5 through 14. The ASA for these dates ranges from 7 to 15 minutes, with the longest wait times at 100 or 117 minutes. Can the company explain why the average wait times are so high during this specific period?
I'm sorry, I just want to clarify that's OCC 5 attachment 1.
Correct. That's the 2024 year, the months of January, February, and March. It's on the right side top of the page.
So though in January specifically, that was when our brand new ACD IVR system was being implemented as we were transitioning from our old system to our new system. And it did take CSR's time to get used to it. And I don't know, Mr. Bajan, if you have anything else you want to add. But the January in particular is when the new ACD IVR system was implemented.
Just for the record, could you state the name of that rather than the abbreviation?
Absolutely. ACD is Automated Call Distributor, and IVR is Interactive Voice Response System.
If I could add, Ms. Church, during that same period, I know my colleagues, there's a lot that's happened in recent years, but we had just implemented a 2-tier low-income discount rate for over 100,000 customers. So we didn't have a baseline for how customers would react or be interested in call. We sent notifications to all of them. And in the gas side, we don't have a discount rate, but on the electric side, those same customers, if you have a verified financial hardship, you will also be handled through our Alorica representatives. So that also caused a bubble in that period of time.
So in the attachment provided, it's not differentiated between the electric side and the gas side. Would that be correct?
No, the attachment provided is gas only.
Okay. So thank you for that information. But is there any further information related to the wait time specifically for gas customers?
Well, I just would add that our CSRs, and I think we've mentioned this in other interrogatory responses, are cross-trained for electric and gas, meaning they can take both calls, both types of calls, electric customers and gas customers.
I understand that, but the information provided in this spreadsheet you just stated was only for the gas customers.
Correct, yeah.
So I'm trying to see if there's any additional information other than what you mentioned in January as to why the calls would have had long answer times in January, February, and March.
So I just want to make sure that we're getting clearly getting across the point here, which is that the statistics are for gas customers, but it is a shared queue. And so the call queues, the fact that they're shared means that delays due to electric matters or call volume due to electric matters would also impact the wait time of a Yankee Gas customer. So what you're reflecting here are the stats specifically pulled for Yankee Gas customers, but impacted by the fact that it is a shared gas and electric queue.
Referring to CAE 25. In the company's response to CAE 25, the company states that it has proposed new bill redesigns for the gas bill. Can you clarify where the proposed gas bill redesign is located in the record?
So for CAE 25, and I don't have that one at my fingertips. However, I think in recent months, we learned that Avangrid had moved forward through their rate case to get their bill redesigned. And we had originally anticipated there would be a separate docket for that, like there was for the electric side. So there's, I don't believe we provided like screenshots or design. We used what Avangrid had shared with us and what we've done on the electric side as a model, which would be to have public benefits clearly stated on the front page of the bill through the illustration that we have on the electric side, and as well have payment plans for customers on payment plans, have that be clearly indicated as the amount due on that front page. And we have a different interrogatory response that lists the cost of that.
And you said that you had some of these screenshots. Where would those be located?
Oh, no, I don't have screenshots. I don't believe I'm not aware of us filing anything. I think we use the words that it would be similar to the electric side. I don't know if Avangrid provided something, but we knew since you approved that through Avangrid that we should not delay and use this proceeding because there probably wasn't going to be another docket for it. But we would like to work with stakeholders on whatever that view would look like. And we can look at what Avangrid is doing for it, but big one is the public benefits charge. And I think that really has been super beneficial for customers and stakeholders in the state of Connecticut to understand how much of the cost is not coming through the utility and maybe driving some policy decisions to get that off the bill from an affordability perspective.
So what, in your view, would be in the public benefits line item in a proposed bill?
All of the, and I don't have any gas. Actually, we do have a gas. In our pre-filed testimony, we submitted a sample one. So give me a minute. All right. So I'm spitballing, as you would say, but I would say we work with OCC and EOE to figure out which specific ones. But for example, and I don't know which charges align to which, but the similar ones on the electric side related to the matching payment program, arrears forgiveness, if we have a discount rate, the cost for energy efficiency, the cost for, this won't have solar on this side. So it'd be supply, public benefits, delivery. Am I missing one? Huh? Oh, great. I have a smarter colleague than me over here, so Marissa, hit it.
Thank you. So that's a great question. Thank you for asking. Currently, within the gas bill itself, there's energy efficiency, but we are also proposing within our Yankee Gas rate case, the EAC rate, which, as Ms. Kane indicated, would include the low-income discount rate costs and other matching payment program affordability programs, and in addition to costs associated with Senate Bill 7 programs that were established, and there's ongoing and likely going forward costs that we expect to incur in those. So with a bill redesign right now, today, those would be the two items that would be included in the public benefits section of the bill. At least based on our understanding, which is very similar to CLMPs, where we have rates in CLMPs bill today, and what the rates included in the gas bill today would equate to.
Your name again?
Apologies, Marissa Peruta.
So whoever is the appropriate one to answer, what is your actual proposal in this application related to the bill design?
The same as what Avangrid proposed that was approved, which is redesign the front page of the bill and the second page using the graphics that were used on the electric side to clearly show those 4 sections. On the electric side, there was a whole multi-year docket to redesign the bill. And so I think we leveraged those design principles, those parameters that Pura and stakeholders had weighed into there to come up with the IT estimate and timeframe. But also we're still open if stakeholders would like to bucket things differently, we could, we're happy to take that input. We just know the electric bill redesign was really valuable.
On RRU 59, attachment 1, the company includes a couple of work orders, descriptions dedicated to improving the voice of the customer or VOC programs. Can the company explain what those line items reference? Specifically, the line items are 21, I'm sorry, I said that in an awkward way, 21, 22, and 27.
It's going to need a moment to pull it up.
Sorry, what did you refer to? I got 59.
RRU 59, attachment 1. Line items 21, 22, and 27.
Still navigating, apologies. Are you asking about spreadsheet line?
Yes.
Okay, I'm sorry. I did have it up, but I was looking at the labeled lines.
Sorry.
Okay.
Which line?
That could have been clearer. My apologies.
So I see, seconds. And you said 21, 22, and 27?
Correct.
So the spreadsheet I'm looking at here ends at line 24. So I think that's why I'm having some difficulty here. Okay. Thank you. Okay, 21.
21 specifically says, excuse me, CX improve VOC VOE. 22 says CX improve VOE, VOC VOE survey improve. And 27 says improve VOC VOE.
And your question is for me to explain the detail behind those? I think I'd like to do a read in on that. I think we can get that information, but I don't know off the top of my head.
Chair, is that acceptable for you at some point?
Yes, thank you. We'll label that read in A.
All right. In reference to CAE 26, but also the Yankee Gas revenue requirement number 2, Schedule C 313, and WP C 313. The company's responses indicate that all non-labor related customer service costs are included within that Yankee Gas revenue requirement 2 and the schedule associated. Can the company clarify whether it is including any other new projects or initiatives in its revenue request in this proceeding related to customer service? Yes, could you just turn the mic on, please? Thank you.
Thank you.
So the question was, if you can clarify whether the company is including any new projects or initiatives in its revenue request in this proceeding relating to customer service.
No, it's not. So if you look at our update to the cost of service, which we filed in mid-May, Schedule C 3-13, we essentially held the test year pretty much consistent, or excuse me, we held the rate year pretty much consistent with the test year. We made a few pro forma adjustments to reflect downward adjustments, and we made one pro forma adjustment to reflect an adjustment for inflation on AT&T costs. So no additional changes were made.
And then regarding some of your trainings, referring to UPA 50, I'd like to better understand how your trainings support the company's commitments, particularly the ESG commitments. Can you clarify how the effectiveness is of the training for your customer service representatives, for instance, is evaluated beyond course completion? For example, is there internal review, monitoring, customer feedback, et cetera? Particularly for customers with financial hardship.
Certainly. So, and Mr. Budgeon, I'm going to look for you to help me with this a little bit. So as part of the requirements for our CSRs, we do our quarterly refresher training for all CSRs, all 4 quarters a year, which includes DE&I or engagement training, as well as soft skills training. So to answer your question on how those things are measured, it's a myriad of ways. So first of all, in the quality assurance program, right? So we look at, is the CSR being empathetic, understanding? Are they aware of what the customer is saying? Are they asking probing questions? All of those things that go towards, are they aware of implicit bias and things that they may take for granted, but customers may not take for granted. All of that is measured. And furthermore, and my colleague, Mr. O'Brien, can assist me with this, we measure things like the knowledge of the CSR, the caring of the CSR, and things like that in our post-transaction survey responses. And we generally, our LORCA CSRs and our internal CSRs score favorably there. And I believe in one of our interrogatory responses, the CSR averaged 8.5 over a period of time. And that includes internal and external CSRs, subject to Mr. O'Brien validating I'm accurate. Okay, that's confirmed.
Since the refresher training is offered, I think you said quarterly, how do you evaluate whether these trainings influence customer satisfaction, particularly among vulnerable groups?
I'm going to ask my colleague, Mr. O'Brien, to assist with that, please.
We could just have him speak closer to the mic if he's going to be more than confirming. That would be appreciated.
I'm sorry, can you repeat the question?
Since the refresher training courses are offered quarterly, how do you evaluate whether these trainings influence customer satisfaction, particularly amongst vulnerable groups?
Okay, so our surveys, I think I can take that. I can go ahead. So the quarterly refresher training is a compliance training that we do for the credit contact center, and includes payment arrangements and the bill assistance training that we do for the Alorica CSRs, and customer engagement and soft skills training on that. How do we associate that with the vulnerable groups? That I don't have the that we can associate with it.
So we don't supplement that, if I could. So we did this beautiful survey at the end of our live call conversations for years called it's like an Uber-like rating of 1 through 5, where we asked all customers who called the collection center, or if they were on the discount rate, like if they had a verified financial hardship or pre-qualified for a financial hardship, we ask everyone to rate us on a scale of 1 through 5. And we would ask them, did we provide you a way to save? We filed that for a number of years. We did consistently very well, 4.8 to 4.9 out of 5 We did so well so consistently that we realized we didn't even need to continue the survey because it was a boost for the reps to see. They could also see open-ended comments just like you can in Uber. But we really do extremely well there, and we measured the heck out of it and filed that in multiple years of dockets for those vulnerable customers exactly. So I think that's the most statistically valid. There were tens of thousands of responses per CSR, or sorry, tens of thousands of responses overall, but per CSR, hundreds a month. This is very strong.
And when did you stop measuring that?
That was in, sorry. That was in 2023. And the score, that if I remember, was 4.81 for the duration of when we were measuring that.
And I believe that was ceased in May of 2023.
And that said, we ceased running that type of survey, but we do run additional surveys for customers, a post-call transaction survey to get feedback from customers to see overall how we're doing.
So I can also share to add to that. Within our surveys, we look at it from a global perspective when we're surveying our customers. We try to make sure that it's representative. We test the data every once in a while. However, when we're looking at our dashboards, we break that down by call volume. And so we're looking at the reasons our customers are calling, and we're monitoring from that perspective. I can tell you customers calling about payment plans, financial assistance, and or to make payment arrangements. Typically, those are on the higher end of our scoring. So I would say that the training is, I can deduce that the training is effective. We do know that approximately in 2024, 20% of our respondents were coded hardship in our systems. So they are part of those numbers.
And so your survey responses are only from customers who choose to engage in the survey, is that correct?
That is correct.
And do you
They're
know
not
do you know an approximate percentage of how many of your customers do engage in those after-call surveys?
Yeah, so depending on the survey, the post-call survey is about 4 to 6%, which it's an email survey, so it's best practice.
Okay. And so you treat that response from 4 to 6% of your customers as a representative of all of your customers?
So-
1 second to confirm.
So I'm sorry, can you repeat your question?
Yes, you stated that that about 4 to 6% of your customers respond to those surveys.
Yeah, so
My question is, do you treat that 4 to 6% responses as representative of all your customers?
So in Connecticut, we send about 1,000 surveys out a day. It's randomized. We collect more than 500 surveys a year. Actually, we probably collect a couple thousand, so that is statistically significant. That's just in one of the surveys, and that's thinking of Connecticut as a whole. I also want to offer that the post-contact survey is not our only channel for collecting data from our customers. We also have our relationship surveys. We have other transactional surveys such that we're collecting data on.
Okay, I don't think you quite answered my question. I'd appreciate it if you could. You treat those 4 to 6% as representative of all your customers?
Yes. And when you're thinking of a population, anything over 383 responses within a given period is considered statistically significant at 95%.
And what's that
confidence level.
given period?
So for Connecticut, I'd have to get the numbers for you. I can do a reading for that, but we typically look at both a monthly and annual level.
I would appreciate a read-in on that, Chair.
Read in B.
Thank you. And also, if possible, we'd appreciate an LFE. If there's a final last survey response or report from the study that was discontinued, that would be appreciated.
You're referring to the Uber-like, what we called Stella Connect that Ms. Gaines spoke of?
Yes.
Okay, that's no problem.
Thank
For which time frame would you like?
I think we're looking for your if there's a final report, that when you concluded, the program.
Okay, because we have it by month and by year, so if there's a particular time frame.
You concluded it, I think you said in May, 2023, perhaps to the January through May, unless there's a final report that summed everything up. That would be our preference if there was some report summing up why it was concluded and things like that. But otherwise, January through May of 2023 should be sufficient.
We can do that.
Thank you. And then, do you have any sort of feedback loops between your training effectiveness and your frontline performance metrics?
Can you ask that question again? I just want to understand before I answer that.
Sure. If you have any feedback loops between your training effectiveness and then your frontline performance metrics.
So we do have metrics that measure the quality assurance of the CSRs, and that's built into our contract with our third-party contact center vendor that we have. So that's how we measure the performance for the CSRs in terms of training. And we also have other avenues that we engage with the vendor team on a weekly basis, where we listen to calls, we do calibration with them. My team also listens to calls independently, and we provide that feedback to ensure that there's consistency in terms of new hire training, in terms of quarterly refresher training, and what's being delivered on the phone call. So that's how we close the loop of delivering training and then measuring in the performance.
If I may add to that too, sorry to interrupt, but what I would add to Mr. Bajan's comments is that I think each one of our call center metrics potentially could be provide a line of sight into the effectiveness of our training. So transfer rate, for example, would show a rep's confidence in a particular topic. The quality scores that Mr. Bajan referenced also would allow us to hone in on specific deficiencies or areas where we're training very well, and then also that post-contact satisfaction, specifically the overall score, as well as any comments that are coming up in those surveys that would suggest that we might have a deficiency in a particular area. So we review those on a regular basis and could take action from a training perspective if that kind of insight surfaces.
Before I move on to a slightly different topic, I wanted to circle back just to those incentive payments that you discussed in that new contract, or the new potential contract. So those incentive payments would technically be covering improved performance for other company customers. Is that right? It wouldn't simply be for the Yankee customers?
That is correct. The performance-based rates contract would be for all lines of business that Alorica provides service to.
Okay, so are those shared on a proportionate basis? Are they billed duplicatively? How is this shown? How do you differentiate the billing between the Eversource customers, the Yankee customers, for instance?
Mr. Bajan, can you answer that, please?
Yeah, so we have dedicated customers that call in, and CSRs basically that manage Connecticut calls, whether it's electric or gas, and that is how the billing is done for Connecticut customers, which is different than other operating companies that Alorica services.
Okay, I think I'm asking specifically in Connecticut between the gas and the electric companies. How are you separating that out?
So the calls are tracked by skill, so we can track which calls were taken for Yankee Gas versus which calls were taken for Connecticut Light and Power. And also, I think this may be what you may have also been asking. It is one rate for all lines of business there. It's not different for Yankee Gas versus CL&P versus any other operating companies.
Okay, so if for instance, your Yankee CSR, or the CSR's answering responses for Yankee questions were doing terribly, but your ones for the CL&P were doing excellently, would you then get an average, or would you treat them separately?
Can you ask that
Would you-
question again?
Sure. I think without seeing everything in front of, it's hard to sort of talk about this in the abstract. I understand that. You're saying that you're able to track between which types of calls your CSR customers answer, CLMP and Yankee. And we have the same set of, as you called them, PBR metrics for your customer service representatives. So as you're tracking these, I'm making a thought experiment that say all the questions that end up being related to Yankee are having negative results. We're not getting the performance metrics you're looking for, but the CLNP directed calls end up being better. When you're taking these performance metrics and creating your positives and negatives, are you separating Yankee and CLNP, or is it averaging out such that you might actually be getting a very positive or a middling result or a more negative result for one company versus the other because they're all being looked at the same time?
Okay, so I can answer that. CLMP and Yankee Gas, from a customer standpoint and the offerings to the customers is, I think it's like mirror image. It's exactly the same in terms of following the script, in terms of offering, the programs and the plans and what are the, issues and concerns. That's why we have.
1 second.
Okay.
So I believe, Attorney Church, the answer to your question is that in the contract incentive structure that we're setting up, there will be one effective rate that all Alorica hours worked for us or minutes worked for us will be compensated on. Now, that being said, we do have granularity, as you were correctly observed, down to the individual level. So just because the incentive level for the contract is done at the average rate for all of the Alorica reps, regardless of the operating company that they're supporting, we will still micromanage down to the Yankee Gas level to address those issues. We will not be happy, nor will we allow them to be happy with exceptional performance with one opco, but inferior performance with another. So even though the incentive would be paid accordingly, that would not be the end of the story. We would absolutely follow up with them to address any.
And is that reflected within your proposed contract?
Well, I think the question is, I'll consult with my.
Of course. As my colleague consults, just for the record, not ironically, like many of our customers are dual customers, gas and electric. And so there's not like a perfect split in that way. And it is, there's one arrears forgiveness program now effective last November with the matching payment program. Ideally, we'll get to also having a discount rate that's pretty similar on both, but the script for everyone, like Bernie, my colleague, was saying, everyone with a past due balance, it's the same exact sequence of pre-qualifying for financial hardship, pre-qualifying, if not, then pre-qualifying for medical, offering the lowest monthly required payment amount, offering solar, all that stuff. So, all right, back to you.
I confirm the answer to your question is that yes, because those quality reviews that we've talked about as being a critical part of our vendor management relationship are stipulated in the contract and will be stipulated in the future contracts. So yes.
Okay, so there's a way to manage that.
Yes.
Written into the contract. Thank you. Just one quick follow-up on your question. You mentioned they're both gas and electric customers. How many of your customers are both gas and electric?
Subject to 100% verification, but it's 65% have both gas and electric.
According to my notes, it's 152,000 out of the 252,300.
And then one final question before, Chair, I think I'm moving on to a different subject within this area. But is you talked about the fact that Alorica is already meeting some of these targets. You want them to be better. When did you start measuring Alorica using these targets? I know that the contract isn't signed, but it seems like you've already engaged in some of this. When did that start?
Beginning January 1st of 2025.
Thank you. I think if I could just have a moment to see if there are any additional questions on this area. All right, I think before, short of moving on to our questions regarding the low-income discount rate, if this was a good time to break.
Yes, so we will take our lunch break. We'll reconvene at 1:15. Great. Welcome back. We'll go back on the record. Are there any administrative matters before we resume cross? Great. Seeing none, I'm sorry, Attorney Long.
I just checked your document and realized that the original.
Thank you. Thank you, Attorney Long. Okay, if nothing further, Attorney Church, please.
Thank you. Two brief follow-ups from this, but prior to lunch, before I move on to LiDAR. The first, thank you for discussing with us your specifics around the proposal of the bill redesign. Is that in any written form somewhere in the docket?
Yes, it is the proposal and the IT costs to implement, and I'll just look up and provide the cross-reference.
Thank you.
OCC 509, that provides the total cost. Is it helpful if I open that one, or is that sufficient?
It's the costs are helpful, but also any about the actual elements of the design would be a helpful reference as well.
So in 509, we stayed at a high level and said similar to electric. So we, regardless of where the details are put in the categories, stakeholders or Pura can still explicitly rule on that. Whatever was given to Avangrid, we were just going to do that.
Okay. So your testimony today, CAE 25 and OCC 509 cover your proposal, would you say? Just want to make sure we aren't missing any additional.
What? This is 509. Oh, yeah. Yep. And in 509, we had a supplemental 01 attachment. So I think the total cost, if it's helpful, is about, or actually you can just refer to that.
Thank you. My other follow-up question is regarding both penalties and incentives. I understand that under your current contract with Alorica and the one that you anticipate will be signed soon, that there are ways to, that there are provisions for both incentives and penalties. So the question is how both currently and going forward, do you measure the accuracy of the content of your credit collection calls, what the folks actually say for accuracy? And how does that currently play into incentive or penalty, and how will that play into incentive and penalty?
Can take that. So in our current structure, incentive and penalty structure, the content and the coverage of giving out right information is covered through quality assurance. And also, like Mr. Lawrence mentioned, that every facet of our the performance-based rate design that we have, whether it's transfer rates or it's hold time or the feedback manager, basically the customer review coming back, the longer the CSR is taking, all of that on an overall is about how comfortable or how good the CSR is on a performance standpoint. Besides that, we also have, I had previously mentioned that different avenues where we do calibration calls with our vendor on a weekly basis. There are multiple avenues. We listen to their calls. We provide that feedback. And that's our strive towards getting better and, improvement in the training and what's delivered to the customers, basically.
And when you're listening to those calls, what specifically are you listening for?
So our training and what we listen to is the Pure approved script and the call flow that we had from EOE that was given to us, and making sure that the CSRs are following that script and that call flow and offering everything to the customer as an option.
Are there any times that folks go off script appropriately, i.e. we've completed the script, but then there continue to be more questions?
Can you ask that question again?
I'm wondering if there are times when your CSRs would go off the script, not that they're improperly going off the script, but properly, we've completed the script,
Mhm.
but there are additional questions from a customer. When you get to that point in the call, what are you looking for in terms of accuracy?
So let me answer your question with an example. So when we say a script or a call flow, it is not that, can we ask you hardship pre-qualification question? So then they go down asking hardship pre-qualification questions. There's a lot of back and forth that happens, and the call doesn't stick to the script. There is a gamut of information that's shared from a CSR standpoint, from a customer's perspective as well, on a variety of subjects. And it's all well within the training and the information that is provided. The only guardrails that we have, and that's covered through our quarterly refresher and even the new hire refresher, is the soft skills portion of it. Keep the call control focused only on providing the services to the customer related to their account, and try and give them the best service as possible, and not talk about anything personal, just related to the account, and take care of the customer.
And Attorney Church, if I may, just supplement Mr. Bajan's response, I think to hopefully further answer your question. So we don't just look for, did the CSR follow the peer approved script and the guidelines provided by EOE in previous dockets? It's, did they get them on the best plan possible that the customer could be on? Did they take care of all of the right things that are supposed to happen? If there are other questions that are unrelated to the peer approved script or the call flow, of course, we want to make sure that they provide the right information and do the right thing. So for example, if they take a payment, the customer wants to make a payment, did they take it correctly? Did they follow the appropriate steps and processes and things of that nature? All of that is measured as part of quality assurance. And as Mr. Bajan mentioned, we do multiple calibration sessions a week, which is kind of a bit beyond the best practice, but we feel that it's important to do. So we look at all of those things, make sure that we're calibrated and that the CSRs have all of the best information to get the customer on the best possible payment plan and ensure that they're pre-qualified and go through that whole process.
Okay.
Can we confer just for one moment, please?
Sure.
We're good. Thank you.
Thank you. All right, moving on to, okay, that is on, my apologies. Moving on to some questions on the company's proposal on LiDAR, the low income discount rate. In the company's response to interrogatory OCC 66 and its supplemental replies there to that as well, the company provided a 5-tier LiDAR structure that includes tier eligibility data from the Department of Social Services, DSS. And the 5 tier looks like it was 5%, 15%, 20%, 40%, and 50%. Can the company explain how it calculated and arrived at those tier discount levels?
We can. Thank you. Thank you for that question. First, there's no perfect answer. So we should start with that. On the electric side, this went through about 4 years of its own docket, but we wanted to act with a bias for action to help our lowest income customers with that 60% or below state median income with a discount sooner than later. And we learned this spring that Avangrid had done that through their rate case. So what we tried to do is leverage the best of the authority's decisions on the electric side and what we saw with our Avangrid partners in that decision. And then we married it with our beautiful Department of Social Services data matching that then provided insight into which tiers of household income that our specific gas customers fall into. Again, there's no perfect answer, but I can walk through if it's helpful. Or we can walk through this spreadsheet. It is created as a working spreadsheet. I think OCC, EOE, and Purist staff and others were participants in the electric docket where that spreadsheet you can model. You can do infinite what-if scenarios. I think we probably did 2 or 3 dozen. But for key assumptions that we used, first I'll start with, so I'm on OCC 66 supplemental 02. And in that same narrative, we consistently always included the prior response too. So I'll do the working backwards game a little bit. So in December, we'd said, we reached out to the Department of Social Services and we look forward to getting data matching for our gas customers. In March, we received it and then we provided that. So that spread, about 5% of customers am I in the right place? Yeah. 5% of customers at the 200, well, I don't need to go through, I guess, each of the household incomes. You can see that graph. So that's the data we had. With that data, then we took the next step, the final step with supplemental response number 2, and put that data into the working Excel spreadsheet. So I'm going to pull us to the working spreadsheet. So that's attachment 1 SPO2. And then here are the assumptions, and my colleague, Mr. Trainer, will help make sure I stay focused. So first we used the items that are highlighted in yellow, for those who are looking at a colored version, are the ones that you can provide input into. They're the levers that you can play with to figure out, where do you want to land. But we started with a consistent framework compared to what we have on the electric side, which the Office of Consumer Counsel had highlighted New York State had. And that is where PURA last fall had decided, you know what, we're going to have a budgetary cap, not a hard cap where customers, like if the cost hits that, they just fall off and get no discount, but a budgetary trigger to review the tiers and the amount of the discounts to see, are we giving too much or too little? So 2%, we just kept the exact same thing as the electric. And then that measures itself with each scenario. The usage cap, that's another key variable. So we understand that with Avangrid's decision, there was a decision in their rate case to do 10% flat, but we had some input that might have just been because to expedite the proceeding and not necessarily that was the end state actually targeted. So we used the best of our knowledge and the benefit of the time we'd had since Avangrid had been in there. And we knew that stakeholders in PURA had supported a usage cap on the electric side. So we picked, for the usage cap, there were 2 top scenarios that we had played with. One is, so again, we're on attachment 1 of SPO2, is the average, so on row 31, the average usage, and this is for customers with a verified financial hardship who are heating. Right? Yeah, and 95% of our financial hardship customers, financial hardship gas customers, do heat with electricity. So gas. Yep, sorry, not with gas. Yeah.
I understand.
Thank you. See, this is why. Yep, keeps me honest. Okay. So that monthly average was 54, which was pretty low given how much gas low-income customers would really need in the winter months. So then we took a slice, and in the blue, we identified, let's look at just the heating months, the ones that, for example, LIHEAP would consider heating months. And we took that average, and that is 90. So these are working cells. So row 13 captures that the average usage during November to April was 90. So we use that as a usage cap, and that also helps manage the total cost of the discount rate. In addition, it helps it helps prevent creating an incentive for customers to use a lot more, period. So let me pause on key assumptions from this page. Are there any questions from this page? Because those are 2 of them, and then there are additional ones.
Please continue.
Okay, great. Okay, so now we'll go to page 2 of this attachment, and this will look very familiar for those who were part of the electric docket. It'll look very familiar there. But that orange big box on row 13, so the average energy burden target, we picked 4%, which was, there were a bunch of different data points on the electric side. it landed landed around 4%, but the original research was the ACEEE research from 2018 that said your total household, your total energy burden, household energy burden should be 6% or less than your household income. And yet that kind of drifted. The whole industry didn't find it super useful because we don't know who uses oil. And we actually can't tell if your primary use is your split mini ductless system or your oil system. So consistent with the electric side, I believe we picked the 4%. Is that approximately where it landed? But it's like a circular, almost a circular reference, because this 4% might need to be adjusted to make sure we don't go over the total budgetary cap. So we picked 4%, but you can plug in 2%, and then it blows the cap out the door. So we picked the scenario that didn't blow the total cost cap out the door. That's where we landed after several iterations. On this page, the other analysis that it's newly captured in a spreadsheet, but we had talked it through, is rows 8 through 12. We wanted to make it really clear what is an average household income for customers in these ranges, because you hear like federal poverty level percentages, it doesn't resonate from a people perspective. So we took each of the ranges. So in, let's say, column 1, row 9, those are the household income ranges. For example, 212% of federal poverty level to 275%. And those are the ranges. Let me know if I've lost you, if you're okay. Those are the ranges that the Department of Social Services came and provided to us in testimony or hearings last July. They actually recommended here's the best alignment of these levels based on all the programs we run. So looking at that, we picked the row below it, just picks the midpoint. It just takes the delta between the two and picks the midpoint. Then we took the 244%, and we know from the Department of Social Services, they told us last year in that same July hearing that the average household size was 1.8. So we picked 2, and that's actually consistent in Massachusetts as well. So we took 244% of the household, the 2-person household, of that 2-person household size, and that's where we got the 49,771. So we're just trying to make it real. And that would turn, so that's the annual salary, annual household income. The row below it just divides by 12. So it's like that, they make $4,000 a month. So a 4% target would be, their monthly average gas bill would need to be $166. So again, you can play with the 4%, but we tried to leverage assumptions that were already fully vetted in the electric rate case as far as what income brackets to use. DSS tells us how the average size. So is there anything on this slide, on this page that has questions? If not, I'll go to the next one.
One question just on the federal poverty level assumptions, because I haven't checked on this recently. Is that gross? Is that what are they using for their the assumptions?
Gross.
Thank you.
Yep. Thank you.
Proceed, please.
And it changes every year, so.
Yes.
Okay. Any other questions on that one? So then the last fun one is the page 3. And so what we started here with where Pura landed on the electric side, and that's actually where we landed. So we did some other variations because we were trying to make, so here's what we were looking at, right? The tiers of the discount. So row 4 has the 5 different tiers. Right below it is the number of low-income gas heating customers would fall in each tier. The monthly average bill, so undiscounted, the monthly average gas bill is $105 for, is it for these customers or no? Yep, for residential, okay. We took the percent discount in the yellow, and you could play with those. And that will give you, here's how much it's been discounted, the total amount after the discount, and then where does it land? So if you're in the green, there's conditional formatting that I'm a little bit proud of, that makes it green if you're below the energy target that's on that prior page in the orange, and it puts it in red if you are above it. We had this similar issue on the electric side where that lowest income group, and again, if you look at the prior page too, the lowest income group goes to zero income. So the midpoint of 0 to that 100%, that's like very low. But ultimately for the electric side, that deepest discount for those customers who needed the absolute most, that wasn't reached, that energy burden target wasn't reached for those customers either, primarily due to the budgetary cap. So with this scenario, it lands at 2.04%. So with rounding, it's 2. It seemed to come closest to the pin because then we thought it was easier to communicate to customers when they call Bernie, whether they're gas or electric, if they're low income, it simplifies to not have 2 different things. And that said, it doesn't need to. And so the other part that's very important is always calculating the cost to all customers to do this for any of our benefits. So that brings the total cost lands at 2% of the cost to fund this discount rate would be 2% of annual billed gas sales. The average cost per residential gas customer to pay for it monthly is $1. I think on the electric side, it was more like $5 or something. Maybe not. Delete reference to electric for a minute. But $1, and then the average bill impact for all customers, meaning inclusive of commercials, like $3.74. So the key assumptions in summary are: what's your energy burden target? Do you have a usage cap? If so, what should it be? And you can change that over time. How many tiers should you have? Whatever we build up front, we should build enough so that if we want to use more later, like build it, and then it's much easier to build it once and then don't use it if you don't need it. And then the percentages, which over time might change depending on whether it hits that target. So we really tried to stick closely to electric, but leverage the DSS data insight that we had, because we really want to have a discount rate for our gas customers, and we were a little jealous that Avangrid got to do it ahead of us. But we also are open to, like, if we really did think there would be its own docket. So if stakeholders have a specific perspective on which way the discount should be, we're open to that as well. But the cost estimate from an IT perspective to build it, regardless of which the assumptions are, like what percentage discount, that doesn't really make a difference from an IT perspective. I think the IT cost was $2 to $2.5 million in 12 months. That's consistent with what it was on the electric side. So it's for all of our gas customers as a gas company.
So you mentioned mirroring some of what you did in electric with the gas. What exactly did you mirror?
Good question. We mirrored that there is a usage cap. We made the usage cap more forgiving on the gas side than the electric side. On the electric side, the usage cap was I believe it was the average monthly usage over 12 months versus the average just over the winter. So we leveraged that framework, and I think I have a response that says what else we leveraged, but we'll go from 5 tiers like electric, exact discounts like electric, 2% of the total billed sales budgetary target like electric. Anything else? The DSS data matching like electric.
So really, I guess the more accurate question for me would then have been, what isn't the same as electric? It sounds like
Usage cap.
Usage cap and the monthly, how you created the monthly average, essentially.
Yeah, it's just what the usage, the basis for the usage cap. Do we want it? If it blew out the budgetary target, the 2% budgetary cap, we would go, then one of the options you have is you could go to average. You could go to the average 12 months. So it is a lever to choose later, but since it fit under that, we thought it was consistent with stakeholder feedback of having one and yet allowed people not to be too uncomfortable during those winter months.
And looking at these tiers, is there any double counting of customers between one tier or another? Given that some of the data is from DSS and some from you, or is every tier, does it contain only the customers within that tier?
This contains only the customers within each tier. They move every day, right, in real life, but this is, DSS gave us this just for our gas customers. And it was very reliable once we got it for the electric customers as well.
Did you target a specific household energy burden with the discount levels?
On the electric side or this one?
This one.
In this one, that page 2 in the orange box, row 13 is that target energy burden of 4%.
I'm sorry, I didn't have
That's
it
all
up in
right.
front
There's
of
a
me.
lot. I love the questions because we're proud of this thing, so we're good.
And you discussed that part of the choice of that burden was sort of making the numbers all fit within the budgetary cap. Is that correct?
Exactly.
Is this the structure that you propose that the authority adopt?
Yes. Best we got, right?
Regarding the IT estimate, you mentioned that it's a cost of about 2 to 2.5 million over 12 months. Is that correct?
Correct.
Can you explain the basis for those cost estimates and what would be included in the costs?
Yes, and I would love to invite my colleague up from IT, Dean Coco, to join us at that mic. And then I think I'll also refer to, is it OCC 67? Dan, if you can pull that up, that has the IT costs. You might have brought that up too. And so the question was around the basis of the $2 to $2.5 million.
And what's included? Yes, thank you.
You bet.
Yes. Sorry, yes, David Coco, IT Director of Business Solutions. So our process in IT is we follow a normal software development life cycle. So 12 months is not merely just doing the code and building. We assemble a team. We go through a requirements process to ensure that we've captured all the requirements clearly. And the purpose of that is within our mainframe, which is about 70% of the total cost that we've shared, roughly 2 to 2.5, so 70% of that cost, we go into our mainframe and we have to make code changes to various modules and tables, as my colleague mentioned, for some of the algorithms and some of the logic in place. So as we go through the build, we conduct testing. Those testings are part of the cost as well. We partner with Ms. Kane's team as well. We have a close partnership, so they're alongside for the ride in our projects. And it takes into consideration a large amount of regression testing. So our C2, which is our mainframe customer information system, is extremely critical to our operations. So it requires a significant amount of testing and regression testing. The system itself is about 20 years old, and it's on.
I think, yeah.
Yeah, and it's on, so we do require some testing just to ensure other processes are not impacted. So the high level cost we've provided at the time is the 2 to 2.5.
And Ms. Church, and Dave, if we refer to, what's this number? OCC 67, which unfortunately I didn't print, but that explicitly shares that the IT effort includes CSR interfaces, the back end we need to modify. We have a lovely social agency portal so that at the dozen or so community action agencies that we partner with, we train them when they come in to just enroll customers right there in the discount rate. So we need to make changes to that. The file transfers between us and the community action agencies, we want to be super efficient. So if they can identify which tier they're in, we just want it back in those tiers. We've got the files for DSS data matching. So our monthly data match, which is rather a blunt instrument, but we receive a big file of hundreds of thousands of, well, our million electric customers currently, but the 150,000 residential customers. So every month we will now start sending them all of our gas customers, and they will send back. Ideally, it's a 1 through 5. If we have 5 tiers, they just tell us which tier to put the customers in based on the matching. Bill presentment. So we need to, this IT estimate also includes the inclusion of the discount recognition on the bill, just like it did on the electric side, which is, I think it's just like a page 2, but it's a new line item that would display. In addition, the costs for the discount rate would be, I believe, in the proposed EAC. So like there's 2 separate estimates. One is doing the discount rate and the other is the bill redesign. If they happen at around the same time, then they can, there's probably some nice synergy there, but also just knowing where to put that, the public benefits piece, and is this included in it or not, would be important to know upfront. Notifications to customers, so via letters or digital channels. So we send a lot of those today. For example, for electric customers, if they provide their financial hardship information, they're either verified, they're not verified, or then we need more information. We currently send those notifications back to our electric customers. We'll need to do the same thing for gas customers. The creation of a place, well, if the authority doesn't go straight to a 5-tier, we would recommend that whatever structure we have, we start in that structure, because the transition is painful for customers and stakeholders, I think, as well. So I think go right to that 5-tier. And then reporting, because we know there's a lot of reporting and what if scenarios. So those are the cost types that would go in, that would go into this, I think.
That sounds very similar to what's already been implemented on the electric side. Is that correct?
Yep, for that. Yep. Different. This one is a different operating company, but we get some synergies from that concept. And it's similar to what we had in Western Massachusetts through our same customer information system, and in New Hampshire, where we also have a 5-tier, but you have to build it for each operating company.
And on the electric side versus the gas side, do you use the same internal IT technology?
Yes.
Okay, so given that, can you explain to me why that can't be transferred from electric to gas?
We wish it could be. We wish it could have been transferred from New Hampshire down. It's structurally not capable of doing that. But Dave, you can help speak to that.
Yeah, as Ms. Kane mentioned, the way that our CIS system is organized, it's organized by OPCO. And with those OPCOs, there's separate tables and operating companies, different tables and modules that have a string of code. What's reusable is some of the logic that we put in place. That logic we can kind of extract and also manipulate in a way that make it applicable, but still the same code base, or not the same code, the same logic. We would have to touch different modules in a various number of different tables to change the code base for that specific operating company.
So you see it as an equal amount of work to create whole cloth for the electric side as to create sort of a partial, moving some parts of it over, creating parts of it for the gas side.
I'd say in some cases, it's an equal amount of work for the amount of testing we would have to do. For the development, some of the logic, as I mentioned, that we've built as part of electric, it's a smaller amount pulling that forward.
So is there any discount in the costs for the fact that some of that logic is already built, or has that not been accounted for?
We do have, we captured in that same response that this estimate is less than what the electric side was. I think we could read in where the electric side landed, if that's helpful, but it is, if I can't find it in what we've already filed.
I think I'm less interested in the specific amounts of where electric landed versus this, but in understanding which areas it is that there is less cost because it's already been built. So for instance, you've got the CSR interfaces, right? Is that something that has to be newly built, or is that something that can be pulled parts from what's already been done on the electric side?
if we, I think also we gave a wide range, like 2 million to 2.5 million because there were so many open questions. The more consistent it is with electric, probably the higher likelihood of leveraging more of what's already there. For example, if the discount percentages are different, do you need like a whole duplicate set of screens that's just for gas? And so
Just for the ease of this conversation, just assume that the discount amounts are the same as you've proposed. If everything is the same in that way, would the CSR interfaces have to be made whole cloth, or is that something that can be brought over?
so I'm gonna, oh, go ahead, Dave.
If you just give me 1 second, I'm just checking my notes.
Thank you.
And as Dave is speaking, so there's a few different CSR interfaces. There's one with C2 that our customer service reps look at for customers who don't have a past due balance if they're calling to move in or move out. So that's one screen. In addition, there's the payment plan portal or Bernie on the Alorica side for what our folks are looking at there. I think we're brainstorming in real time.
I understand.
So after reviewing my notes, and again, preparing with my development team, we have a different, as Ms. Kane mentioned, a different CSR interface. That is not going to be essentially something scalable that we can reuse. Things that are reusable in nature are things, for example, for mass enrollment into the LIDR using the hardship data from DSS, that's part of the file transfer logic, can be considered reusable. The auto removal process that we have for electric is also, that logic can also be removable. We have some modifications I've mentioned in the front end, so similar look and feel, but again, it's in a new system, so there's additional build that's going to be required there.
Okay, I'd like to ask for a late file, Chair. If you could take, at a minimum, the list, and I'm not going to count incorrectly, but that list that you've come up with in OCC 67.
Yep.
If you could take that at a minimum, that list, if there's more you'd like to add, that's fine. But if you could take that list and break down for us both which of these can be reused in what way, if they can't be reused, an explanation of why, and the approximate percentage of the total that accounts for, estimated. I understand that these can't be hard numbers, which is why I'm saying estimated percent. So is the CSR interface, is that going to cost 50% of your bill, of your estimated 2 to 2.5 million? Does that make sense?
I get it. So I think it's two parts. One, like of those bullets, kind of a proxy for the percentage of the total cost that they represent. And secondary is how much of these change efforts are, how much they're able to leverage the electric side.
Yes.
Yep. And I do know none of us, we all aim to squeeze in the synergies for, because if it's simpler for the CSRs, then it's also simpler for customers and call handling and all that. So we definitely consider that whenever we're building this.
And for the purpose of this LFE, also please feel free to assume the same percentages that you've proposed to match with the electric side.
Okay.
Chairman, was that late file Exhibit 5?
Yes, thank you, Attorney Pace. That's late file Exhibit 5.
All right. Just reviewing to see if I have any more questions on this. 1 minute. And then, Chair, I have one more request for LFE, which is that the company use the cost, I'm sorry, that the company provide an LFE which uses the numbers in OCC 66 as an estimate for that structure. For the overall cost.
Just to paraphrase back so I understand, so meaning in estimating the IT costs, use the assumptions? Yep, and that is what we. Nope, I understand what you're saying, because I think after we, between supplemental file one and 2, there was a request for the usage cap. So yep, we can do that.
Just to clarify, is that a new late file exhibit or combined in late file 5?
A new one, please.
Thank you.
Thank you.
Late file exhibit 6.
Yeah.
My colleague has just a clarifying question.
So this is Authority Staff Jenna Vigra. So I just wanted to clarify. So given that the company has provided an IT cost estimate of between 2 and 2.5 million based on kind of all of these open questions, I think what we are looking for is provide an IT cost estimate using all of the design elements you provided in OCC 66 so that we have kind of a more tangible understanding of what the cost might be.
Narrow down the ballpark using these assumptions. Got it.
Okay. Yeah, including the usage cap, the discount levels, the structure, et cetera. Great.
Thank you.
Okay, thank you.
That's the extent of my questions, Chair.
Thank you. Both. Great. So the authority staff is all set. So we're going to transition to cross by the Office of Consumer Counsel, please. Attorney White, please.
Hey, good afternoon. Kim White with OCC. So I'm gonna start with some things I heard Pura staff talk with you about earlier. And so I'm actually gonna start with the performance-based contract that you were speaking about. So I just want to clarify, that's not in the record, right?
I do not believe that is in the record because the contract has not been executed at this point.
Okay. Do you know when it will be executed?
So we will need to confer with our colleagues in procurement, but we are hoping sometime within the next couple of months, if not sooner.
Okay. Are there any parts of it that are finished right now, or is it wholly
Ms. White, if I could interject, 'cause I think we did have a discussion about this. I think what might be missing too is that we have had performance-based contracts. They just weren't based on the rate. There were financial incentives and penalties all along. I think knowing I think that's where you're going. And I think my colleagues are happy to speak to that. We don't want anyone to have a misperception that this is the first time that we've had performance-based contractual agreements.
Just to add to what Ms. Kane is saying, that we've enhanced our contract, but our incentives and penalties has always been in place with the vendor, basically. There were different metrics that we were gauging them on.
Okay. I'm sorry.
No, I'm all sorry.
Okay. And so the new contract, if I heard you correctly, though, it just does the. Let me take a step back. The current contract under which you are operating it, is it the one that you provided in the response to OCC 12?
No. So since January of 2025, this year, we have, we're gauging them on
the new 9 metrics that's not being signed as of now. We've put that in place. That's just not being signed, but we've kind of implemented that effective January of this year, 2025.
Is that documented somewhere between you and Alorica?
Yes, it has been documented.
Could we get that as an LFE, please?
That will be late file exhibit 7.
Yeah. Can we consult on that just for one moment, please? Oh, sorry.
Just to clarify that we are operating on a good faith on the contract, the new contract that's supposed to be signed on that.
I understand. I guess I just want to make sure I understand what the exchange that you and I just had there. So you said currently that the contract that you provided in OCC 12 is not the contract under which you're operating, and you said you were working under something new with Alorica that you said was documented, and that was what I was asking you to provide
Yes.
in LFE 7.
Yeah.
Okay.
So just to clarify, so we're operating right now on good faith under the contract that we have not yet executed. So I'm not sure, I assume we could file that confidentially as a late file exhibit. Yes, okay.
Yeah, we can file that on a confidential basis because it's still being negotiated, but I think that would achieve the OCC's goal of wanting to understand in more detail the metrics that are being proposed and which, as the witness explained, we've actually started to implement in January. So we can provide that in late file 7 that's acceptable to the chair and OCC.
All right. Thank you, Attorney Pace. If you could submit it under the normal course of requesting a protective order, then we'll mark that late file exhibit 7, please.
Okay.
Sorry, Tom Wheel for OCC. Could I just add, it didn't sound possible based on the testimony, but it sounds like the late file exhibit deadline is June 18th. So if the contract is fully executed by that time, if you could just file that actually fully executed contract, in case that wasn't clear.
In the event the contract is executed by that point, then we would file the fully executed contract at that point before June 18th.
Thank you.
Okay. And I suspect, I was going to ask for another late file, but correct me if it sounds like this might be included in what I'm going to get. You referred to, in your discussion with Pura staff, the 9 metrics and the 5-tier system. And I typed as fast as I could, but I'm not quite positive I got all the 9 metrics. So are the 9 metrics included in what we're going to get in LFE 7?
Yes, they would be included in the LFE 7, correct.
And will it include some sort of explanation of what, so for instance, like what does quality assurance, when you tick through the metrics, like I said, there were broad level headings that I was getting. Is there some sort of explanation of them, of what's included within each of the metrics? Will that be included in LFE 7 too, or do I need to get a late file to help me understand that better?
So let me try and understand your question. You're asking for a specific metric, what's the definition of that metric? Oh.
Or what will be measured by that metric? So for instance, one of the things I definitely heard you say was quality assurance, I believe. So what does that mean relative to the metric? Like, what are you measuring with quality assurance in that regard?
So Attorney White, if I could just clarify to make sure I understand. I think I know where. So what you're asking is quality assurance is one of the 9 metrics that is part of our soon-to-be performance-based rates contract. What specifically is measured and how is the vendor incented and or penalized based on their performance? Is that what you're asking?
Yes.
Okay. Mr. Budgeon, I believe that is included in the explanation with the SOW, but I'll look to you to clarify.
Yeah, I want to say yes, but I think we can go back and check and confirm on that. Like would have.
So what we could commit to do, Attorney White, is that if it's not there, write an explanation with LFE 7, if that would be helpful.
That was exactly what I was going to ask. You anticipated my question. Thank you. And actually, this might be included in what I get as well, but do you know when do you anticipate the contract's going to go into effect?
So I wish I don't have an exact answer. I would need to confer with our procurement colleagues, which is where it's currently sitting. Once the contract is signed, and I would have to confer with them before I provide any further information. But once it's signed, then it would essentially be in effect, because as we had mentioned previously, we're operating under good faith under the terms of the agreed upon SOW as part of the contract.
Do you have any, actually, let me take a step back. The costs in the rate case, are they based on the contract that's included in OCC 12 or the new contract?
It's based on OCC 12, what we provided.
And just to clarify, just make sure I'm correct, Bernie, when we filed OCC 12, that was prior to agreement in principle on the SOW and working in good faith.
True.
Is Alorica your vendor in other states as well?
Yes,
So does this contract cover all states or just
it
Connecticut?
does.
Okay. So then you had said there would be one effective rate in the contract. Does that mean it's one effective rate for all states?
True.
So then can you help me understand how that will work? Because I think I've heard several times from all of the utilities that the customer service in Connecticut is a little more rigorous and a little more difficult than in other states. And you were referring to the script earlier and things like that. So you're going to be measuring Connecticut on the same, you're basically averaging out Connecticut's customer service with Massachusetts or New Hampshire or someone else's?
So before, go ahead.
Yeah, so as we talked about with Attorney Church before, the average rate will be applied to all of the operating companies, but we will continue to monitor quality and other aspects of the performance feedback to the vendor at the individual OpCo level.
Right, but are the incentives based upon the average rate?
Yes, the incentive, there's one set of incentives that are calculated for the performance of all of the reps, yes.
Okay, so, okay. And just to try to help me understand, it seemed like according to the metrics that I had seen in the various interrogatory responses in here, that Alorica has generally been performing pretty well on quality assurance up to this point, right?
True.
Can you explain why you're redesigning the contract then?
So first of all, we have a standard that we have to maintain, and over a period of time, there are other metrics from a customer service perspective that needs to be introduced on that. And instead of keeping the contract the same, we need to add and enhance because things are changing, the environment is changing, the expectation from the client is changing from us to Alorica basically, to make sure that we have overall coverage and certain aspects of customer service that's taken care of. Besides just quality assurance, other metrics also needs to be input on that, which is like a whole 360-degree angle that we take on a contract.
And if I may, I'll take that a bit of a step further. So the world has changed dramatically in the last 5 years, and I'm not just referring to Connecticut, right? And things change. And the PBR contract that we're working under good faith, working to execute shortly, gives us significant flexibility to increase performance standards. And I would agree that Alorica is performing well, but our goal is to ultimately always perform better, right? That's kind of why we're here in the positions that we're in, to work to get Alorica to perform better. And so, as we mentioned with Attorney Church, that the base center rate stays the same, but as they perform better, we will then kind of tighten and ratchet it up a little bit so they can continue to perform better. The old contract, the bonus and penalty was static, if I remember correctly. And the PBR is not static. We can change the metrics that they're measured on every 6 months.
Okay, thank you. Turning to, I'll warn you in advance, I'm gonna skip through some subjects here.
Interrupt you, Attorney White. Can we consult for one moment, please? Thank you.
I'm sorry.
So one of the things that I do want to mention that, and I know your concern was that, it's one rate for all operating companies. But one of the things that I do want to say is that 70% of the volume that Alorica handles is Connecticut. So if you look at it, it's Connecticut that's guiding the other states instead of inverse, basically.
I'm sorry, 70%?
70% of the calls that Alorica handles, like if you look at the overall pie, 70% of those calls are Connecticut calls, will be electric and gas. And then the rest 30s will be in the other operating companies.
And so what that means is that Connecticut has a 70% influence on that effective rate that you've asked us about. And then also too, I think one other thing that we do want to point out is that in the management audit, our multi-state approach was actually leveraged for being a very cost-effective way to contract with a vendor and also marshal resources as needed.
Understood. Thank you. Are you okay if I? Okay. Okay, you briefly spoke about the bill redesign and the public benefits charge. And I'm gonna apologize to Ms. Peruta because I think I'm gonna require to come back up for just a second. I didn't quite understand what she said. She said the public benefits charge would be the EAC and something else, and I missed it. I'm sorry.
Yes, it would be the energy efficiency. So in today's gas bill, there is a CAM line item, and you'll see that if you pull up a Yankee Gas bill, that would be the recommendation of the company that would be included in a component on the bill defined as the public benefits, and that is similar to CLMP.
Okay, so those would be the only two components of that. All of the things that are going to go into, that you have proposed to go into the EAC and the energy efficiency.
That's correct.
Thank you. Okay, turning to another topic that I heard authority staff ask about. There was some discussion, and I had some questions myself about the routing of calls, either the IVR routing and kind of the routing between call centers. So it might actually help me at the outset if I just had you describe both of those, because that might obviate the needs for some of my questions. So taking whichever one you want first.
Certainly, would be happy to. I will start at the IVR level because I think that informs how a CSR would get a call from the IVR. So customer will call either the 800 number for credit for Yankee Gas or the 800 number for customer service. They will go through the IVR. It's a natural language IVR, so you can speak to it conversationally. It can understand, I think, greater than, Dave, help me out, is it either 4,000 or 400,000? I realize that's a large disparity of numbers. I'll validate it. Of natural utterances that the customer can say. So we can say, like, I need help with my bill. I need help paying my bill. I'm having difficulty paying my bill. The IVR will then work to authenticate the customer, right? If they call from the phone number that's on the account, it will ask them to validate the last 4 digits of their ID on file. And then if there's an option for them to self-serve, for example, if the customer is calling to pay their bill, they can do that through automation without having to speak with the CSR. But let's say they use the utterance, I'm having difficulty paying my bill, and they've authenticated, they will then route to a credit and collection CSR. If they're saying I have a question about my bill or my bill is high, they will route then to an internal CSR related to a billing question.
So actually, going to pause you right there real fast because if I can, before we go to the next part, if I can ask a question on that. You said you can see the number that the call is coming from. If you, does it associate in your system? Like if you know the number on the account is a hardship account, does it automatically route the call to the credit and collections vendor?
I don't know if it automatically routes it because there are customers who could have a hardship on their account, but have a question, just a general question about their bill. I can validate that with my colleagues and read in either today or early tomorrow. So I can validate that. I'm not 100% sure.
Okay. Maybe, let me give you a different scenario too. Like, so for instance, if I'm a hardship customer and you can see the number I'm calling from and I say something like high bill, would that necessarily, do you know where that would go?
I do not. Trouble paying my bill or having difficulty paying my bill, I would like to go on a payment plan, right? Those are cut and dry. Those would definitely route to an Alorica CSR.
Okay. If you could read that in to just help us understand how the phone number factors into
Certainly.
routing.
If you give me 1 second, let me just converse with my colleagues. We'll work to get that. Apologies, Attorney Wright. We're just working to get the information. Okay, I think we're all set. And just to clarify, my earlier testimony is 4,000 intents, not 400,000.
Okay, so that's read in C, please.
Okay, so I'd asked you a multi-part question earlier and I interrupted you in the middle of it, so I'll let you return back to your response. So the
Certainly.
rest of my question was not just the IVR, but the routing between call centers, internal to external. So if you could.
Absolutely. So bear with me because it's a little bit complicated. So our new ACD IVR system is a full software as a service in the cloud. And it's skill-based routing, right? So if we're going to use, just to keep it simple, right, internal versus Alorica, it's skill-based, which means that the skills that the CSR is qualified to handle are assigned to their login. So when they log into our system, if there's a call that's coming in regarding that, it will then route to a CSR who has that skill. So we have a variety of different skills. So the Alorica CSRs are skilled for credit and collections calls, the calls that are related to credit and collections, and for billing, moving, et cetera, those are internal CSRs. So based on the selections that the customer makes in the IVR, the system will then route it through the ACD or automatic call distributor to the next available agent who has those skills.
So then, I'm sorry.
No, I just want to make, did that answer your question or?
It does.
Okay.
That answers my question. So then I have a little bit of follow-up.
Of course,
there.
absolutely.
So for example, in CAE 22, you described it, that's the interrogatory, but I don't know that you necessarily need to look at it for the question. You described about an outage and rerouting calls. And so I guess I was wondering, if you have if Alorica has an outage and they're the ones who are in your system, it seems as they're designated that they have the skills to handle credit and collections calls. Do those get rerouted back inside, or what happens in that situation?
Certainly. So they can be rerouted internally. However, and Bernie, you can keep me honest, the majority of our Alorica CSRs are working remotely, and they are on our internal ACD IVR system. So therefore, the likelihood of an outage, quote unquote, related to Alorica is very, very small.
I understand. So it would be a global outage if it had an outage.
It would be a completely different problem. Exactly.
Do the same CSRs handle gas and electric calls?
For Alorica or internal or both? Okay. So I believe we have 80% of our internal and Alorica CSRs trained on both gas and electric. Alorica credit and collection CSRs can handle both gas and electric credit and collections calls. Correct, Mr. Bajan?
Yes.
Okay.
Okay. Next, I'm turning to CAE 14, but I'm not necessarily sure you need to look at it for the question because I'm asking more of a higher level question. So in CAE 14, Section C, you were talking about the use of the quality assurance program to validate the customer service responses and using that for individual performance improvement for CSRs. But in some other interrogatory responses, we talked about other kind of QA things for the CSRs. And so I guess maybe what I'm looking for is a more helping me piece together all of the different QA responses we have in kind of the general like higher level QA for the CSRs picture.
Certainly.
If that makes sense.
Yep, I will work to explain it. If you need additional, please just let me know. So the quality assurance program measures the overall performance of the CSR with the interaction they have with the customer, right? It's did they handle the call correctly, which we discussed a little bit with Attorney Church earlier, but also were they compassionate, were they empathetic? Did they care for the customer? Did they follow up with the customer to ensure they handled everything that they were asking for? And so that is measured at the CSR level, and in CAE 14, I believe that was referencing specifically the overall customer service. No, hold on, I have it right here. Sorry, 1 second.
Section C, if that helps you any.
Yeah. Right. So that's related to knowledge and caring of CSRs, right? So it's both a combination of do customers think the CSRs are knowledgeable about what they're calling about and are they caring about the customer, but also do we see it internally as well?
And on the latter part, do we see it internally as well? That is measured by the quality assurance reviews conducted by Alorica and then the quality assurance reviews conducted by the company on the CSRs and on Alorica's quality assurance reviews.
Right. So said a slightly different way. If customers are responding in a post-transaction survey saying, we think the CSRs are caring for us and they have excellent knowledge of what it is we're looking for, but internally in quality, we don't see that, then there's a problem we need to work to understand kind of what's happening. We're looking to ensure that those two things they're never going to be exactly in sync, but are reasonably in sync.
Okay, my next question is about CAE 16. I will say I'm looking at the confidential exhibit, but I'm not going to talk about specific numbers at all. And I think you can answer the question without having to talk about its specific numbers, but you might confer with your counsel before you do. Can you explain the reason for the directional trend regarding the cost of the calls since 2020?
Attorney Pace, Attorney Tizzle, I believe I can answer that without getting into the actual cost.
Sure, please proceed to do that. Thank you.
So I think directionally and generally speaking, Attorney White, I don't want to get into too many details because it's confidential. Right, we currently live in an inflationary labor market as well as the Great Resignation and all the trends that the entire country saw, specifically in 2022, 2023, explains the directional changes that you're referencing.
Okay, thank you. And I do apologize because I'm going to keep jumping from interrogatory to interrogatory as I'm going down through these. So it's going to be a little choppy where we're going here. Now I'm turning to CAE 24. And in that interrogatory response, you describe, sorry, I apologize. You describe your process for identifying areas of enhancement. Can you describe some of the enhancements you've made in the past few years?
I'll take that. Just give me a moment here to find my notes because I was anticipating this question. So first of all, I'll start in the digital space. We have since 2022 had 22 distinct IT initiatives specifically focused on enhancing the customer experience in the digital space. Those range from just improvements in bill presentment to better ease of taking payments to a number of other items, and we have detail on that we can provide if you'd like to see a detailed list of that. The total cost of that was, I think, about 46 million, and Yankee Gas's share of that was about 1.8 million. Additionally, we've already talked about the enhancements that we've been making in our contracting with our vendor to ensure that our incentives are even better aligned than they've been in the past to drive a more efficient, better quality experience at roughly the same rate that we've been paying. Additionally, we are in the process of setting up and pursuing pilots in the artificial intelligence space. So we've set up an artificial intelligence center of excellence that is actively looking at ways to take advantage of AI within a captive, perfectly secure company data, large language model that will allow our agents to provide even more efficient service to customers when they call. So those are just a few examples here. We've additionally done things to, it actually goes back to the performance management that my colleagues have talked about in our relationships with our vendors, specifically to focus on things like transfer reduction, other efforts to improve the customer experience when a customer calls in, so that they're getting that first contact resolution with the first rep that they speak to. And is there anything else? Oh, and of course, yeah, we've talked so much about it, I forgot to mention our ACD IVR investment is included in those 22 distinct IT digital enhancements as well. That went live in January of 2024.
January of
2024, yes.
You very kindly offered me a detailed list there, and I'm going to take you up on that. Could we make that LFE? I believe that's 8. Thank you. That would be a detailed list of all the enhancements from CAE 24.
Yeah, and that's a detailed list of the digital investments that we made, yes.
Will that include information about the artificial intelligence that you were discussing there?
No, that's in progress.
Could you describe that a little bit more?
Sure. So we recognize that obviously artificial intelligence is offering a fantastic opportunity for us to bring this new capability in and make our operations more efficient, and in a number of areas, not just customer service. And so recognizing that customer data and security are the biggest concerns that we first need to ring fence before we take it any step further. We actually have set up an internal governance model, as well as that, as I mentioned, that AI Center of Excellence sponsored by our IT department to create essentially a captive internal large language model that we are now using for everything from developing basically a CSR attendant to help them better navigate the knowledge base. So if a CSR receives a call on a topic that they are not immediately familiar with, maybe it's an obscure topic that they don't get a lot of calls on, they typically consult our knowledge base. And if you think about our knowledge base, it's basically a database of living documents, of policies and procedures that are constantly changing. And so it's almost a quintessential definition of unstructured data. And so the AI attendant will help them to more efficiently and accurately hone in on the specific insights that they need to better handle a call. That's one example of something that we're pursuing for customer service. A second is using the artificial intelligence, generative AI, to do better speech analytics on calls to more quickly surface deeper insights on call drivers. Those are just a couple of examples, and I believe we have, I believe at last count that I saw 13 pilots that we are pursuing internally in various areas and 17 more that are under consideration.
And you said it's referencing, I heard the word documents in what you said. Like it's referencing things associated with accounts in your system? I guess I'm trying to figure out exactly
Well,
what it's pulling from.
I think that each one of those 13 pilots that I've referenced is accessing a different source of proprietary proprietary data within the company. If I think the examples that I talked about on the customer service side specifically, it's our knowledge base regarding company policies and procedures. It's essentially the job aids, the database of job aids that our CSRs can consult to figure out how to handle a customer in an obscure situation that they don't get every day. So that particular agent would not be access. Yeah, that particular AI-driven agent would not be accessing customer information. There are others, such as the revenue assurance AI agent that we are looking to develop, which could potentially access account nodes, for example, to look for possibilities of unbilled revenue.
I apologize. If I may add, it's not the two use cases from a customer perspective that are currently underway are not tapping into any customer account information. So if you think of the first use case we've brought up is the repository. If I can make it a little bit more real, I think you're familiar with, like, an example is ChatGPT scans the entire internet. It's open. What we're doing here with this repository is it's an isolated database within our own internal environment that we just input documents. So this generative AI is isolated into this repository that holds large amounts of documents. Those change real time. It's essentially scraping and pulling up relevant results from queries that a CSR would do just to look for something. So for example, if there is a question on a particular program and the CSR happens to be new, they would type in the particular program and it's popping the relevant document that's going to be needed versus the time it would take someone to scour through and select it, open it, read it. It's bringing the relevant material to them.
Mr. Coco?
Yes, Mr. Coco.
And just one, if I may just clarify what Mr. Coco said. So think, for example, right, some of the generic formatives we use all the time, like MPP, matching payment plan, payment program, but all of those sort of things. The CSR will have the ability to enter in natural language, like, a question, and it will have the ability to pull it up without having to get it exactly or near exact, right, when there's 4 or 5 different ways you can reference a particular program protection, et cetera.
So I'll be honest, where my mind immediately went was you have hardship customers and you receive their financial documents to know that they are hardship. If that is in any way still associated with their account, are you using that information in an AI world to do anything?
I'll take the first stab and then turn it over to. So the answer is no, we're not using that for any sort of information, nor is it our intent ever really to use artificial intelligence for collections targeting in any way.
Okay. Or even if not collections, I guess from a data security standpoint too.
Yeah. So exactly right. So where Dave was trying to say is like, what we build is in the bubble. Nothing goes in or outside the bubble. We all, like, you're not allowed to, you can't go on ChatGPT from Eversource, from inside the company. So we built an internal AI engine, completely secure, and we have no intention to use the financial hardship proof of household income in any way. We've got a plethora of super high value use cases we would still prefer not to be receiving that documentation because it's PII, the personally identifiable information, non-public information, HIPAA information in some categories. Well, as long as we keep the doctors being the only ones who know that, then we're okay. But no, we will not play with those documents. And those documents are not filed with the customer's information, only the indication of the yes, that their financial hardship is verified is. Yep.
I'm sorry. Actually, my questions. Oh, I'm sorry. So my question's probably to you, Ms. Kane, then. When you receive the information from a customer that their hardship that you received their financial documents, what occurs to those documents? Like you said, there's a notation on their account now that their financial hardship, maybe my question wasn't to you, I'm sorry. There's a notation on their account now that their hardship is what you said. What happens to the electronic document or the paper document if they send it in that way?
So at first, once they come into the system, assuming a customer uploads them from our secure document upload portal, they're reviewed by a CSR, and the account is noted as such. So if they sent in some sort of benefit, we note in the account whatever benefit they receive, or if it's income, we say, 4 people in the household, their income is X, note on the account, assuming it does qualify as hardship, we note the account as such. And the documents are stored securely.
Separate from the
account. Yeah, they're not on the account.
Thank you. Okay, I'm pivoting now. OCC 2. And I'm specifically looking at the attachments. The attachments were the communication sent to customers after they receive a financial hardship designation. But I didn't notice that either of them mentioned SEEP or energy assistance. So my question is generally, when do you communicate about SEEP or energy assistance to the customer in those circumstances?
I can see it just for, so in OCC, for the group, we've got the welcome letter. So meaning by welcome, this means that their financial hardship has been verified. Once that has been verified, we either send them a confirmation via letter or email. I can see that we tell them to visit their local community action agency, and what is protected. But I think this could be, it says other assistance programs, please visit or call us. But I think as far as SEEP, assuming that the federal government doesn't eliminate it, given they laid off 35,000 employees of LIHEAP, I think this could be one we could bring this to the working group, the energy affordability working group, and talk about what if we want this to say, have different words. I don't remember this being reviewed in the last 5 years in the energy affordability or the COVID dockets, but we certainly want every eligible customer to get SEEP. And I do believe we do have a different SEEP outreach. And I'll confer with my colleague here on the SEEP outreach. Just 1 minute. Okay, 2 things. One, and we're going to find out which one it is. We do outreach to all low-income customers who don't have SEEP. We do calls, I think they're robocalls. We're going to find that interrogatory response. So we do that separately. But in addition, Ms. White, I think it would be helpful to have here, our colleagues are just looking to make sure this is the current version of this letter. So by the end of today, if we can read that in, then that would be great. Is that okay?
Thank you, Ms. Kane. Read in D.
Come on. OCC 31. Actually, we might have it momentarily. OCC 31, which I don't have, so.
Attorney White, if it would be helpful, I have read in C, the information while my colleagues are conferring on the other question. So if the customer is hardship coded on their account and they say, hi, Bill, that call would get routed to our credit and collection center. So we did confirm that with our telephony team.
Thank you.
Just taking a read in. Ms. White, we will take that one as a read-in. That'll give us, we won't disrupt people's time later today. Thanks.
Okay. I'll keep going. Is that okay? Okay. Then I'm going to turn to OCC 7. And actually, it's kind of all 3 attachments. And really the entire point is to get an LFE out of this. So this hopefully will go quickly. So, and I do realize we're not exactly comparing apples to apples in this, but I'm doing the best I can with it. Attachment 1 has a tab that's labeled 2020. It has a 2023 tab labeled Total Customer Service Group Count by Role as of 2023. But I don't see that equivalent tab in attachment 2 for 2017. If that makes sense, what I'm saying. If you need me to walk through that again, let me know.
So if you're asking for that tab for 2017, I do understand the question.
Yes. And to the extent yes, that is my LFE request. If you could
Yes.
please give me that tab for 2017. And to the extent that there are new roles between the many years there, if you could describe the job function of the new roles, that would be helpful to me. I believe that's LFE 9.
Correct. That will be LFE 9. And just to make sure I have it fully captured, what was the reference, please?
It's OCC 7. I guess we could call it updating attachment 2. This is going to be hard. Updating attachment 2 to reflect total customer group count by role.
And you had a specific calendar year, correct?
Yes, 2023. I apologize. The
2023.
attachment 1 has 2023 of that, and I need attachment 2 to update it, please.
Okay.
That makes sense.
Thank you.
And okay. I guess we're going to staying on the same theme of LFEs. OCC 20. If we could get an LFE updating attachment 1 to the present, please.
Okay, and that will become late file exhibit 10.
Please, thank you.
And I'm sorry, so on OCC 20, you want an update to current?
Current as it could be, probably by the time the LFEs are due, you could probably do it through May at that point with that.
Yep. we can
If
do that.
not, then April is fine,
Okay,
whichever is
sure.
current at that point. Okay. The next, I'm going to turn to OCC 25. And my question is, the response to OCC or OCC 25 requested any customer service technology included in rate base, and you stated that there was none. I just want to make sure that there's no technology included or in rate base around MPP or anything. C25 again.
I don't have insight into 25, so I know I wasn't the witness on that, but I do know that MPP was not implemented until November 2024.
Okay.
So I think the timing of that would mean maybe our colleagues could help with that one.
I am so sorry. Marissa Prudup, if you wouldn't mind repeating the question.
I was just asking to clarify, there's no technology, there's no customer service technology included in the rate base. So nothing for MPP, nothing for anything.
That's correct.
It's easy. OCC 30. It states that the callback rates are for internal and external call centers. And it's combined, so I didn't know if if the flip of it tells me the success rates, but are the failure rates basically evenly distributed between internal and external call centers?
Don't know if I have that answer off the top of my head. I think I understand what you're asking. So there was a follow-up question. Are these internal and external combined? And what you're trying to understand is the percentage of failure rates the same on credit versus non-credit? Or internal versus external, probably easier said that way.
Yes, exactly. Yes. I think the follow-up had clarified for me that the rates in here are internal and external combined. And I just wanted to ensure that the failure rate, the distribution of the failure rate was evenly distributed. It wasn't skewed one way or the other.
We can validate that, but I would assume so. It's all using the same exact system. So it's not as if we're using a Alorica's telephony system versus ours. There'd be two different callback systems. But we can, if it's okay with the chair and with you, we can take that as read in if we're up to E, I think. And we can validate that information.
Okay.
And I'll just confirm with my colleagues, we can work to get that before the end of the day.
Okay. So in OCC 31 and 87, you stated that you make a call, you make live calls to, I think it was set up payment arrangement and protections. I just want to make sure I understand kind of how these calls proceed. When you call a customer, what are you saying to the customer? What exactly is occurring in these calls?
I can talk through that. So these are live calls, basically. So when we call the customers to set up payment plans and protections, we go through the spiel of the call flow that we follow and give them the entire gamut of offerings that we have to do for the lowest monthly payment to the longest term of the payment plan and hardship pre-qualification, and if they're eligible for the arrears forgiveness plan. So we offer that, and based on what the customer selects, we set that customer up for that arrangement or that program.
Oh, live on the call.
Live on the call.
Do you have a circumstance in which you're taking any sort of payment from the customer live on the call?
No, we don't take payments from the call, payment on the call, because that's not our methodology to call. If they have to make a payment, they can call us and make the payment through the IVR, or make the payment on the web.
And just to clarify Mr. Budgeon's response, we are very mindful of the number of scammers that are out there and how technologically sophisticated they're becoming. And we've generally been very clear that we will not call customers to ask for payment. So if there's a discussion and the customer wants to make a payment, and Mr. Budgeon, correct me if I'm wrong here, we will advise the customer to call the 800 number to make the payment or speak with the CSR and make the payment. while we realize that it's not the most efficient, we also want to make sure that our customers realize that we're aware of this and taking care of them. We don't want them to fall prey to scammers.
Yes.
Um, okay, so I'm looking at OCC 329, which built off of it kind of expounded on EOE 21. And I just want to make sure that I understand the answer of the two of them put together. So if you let me know when you get to the two of them, OCC 329 and EOE 21. I think both were sponsored by Mr. Lawrence as I'm sitting here.
I think we have everybody necessary.
Okay. I'm not, my question is going to be so simple after all of that. I just want to make sure I understand. Are you saying that, and I'm using air quotes because it seems that we have some terminology that I'm having some difficulty understanding in these. Complaints are what are provided in EOE 21 and escalations are provided in OCC 329? In which case that would mean a complaint is what goes to EOE and an escalation is what comes from the customer?
So I will start, and if Mr. O'Brien, if you need to jump in, please by all means, unless you want. Okay. So yes, and Mr. O'Brien can speak to what's defined in 21, but escalations we define here in this OCC 329 there are situations that happen every day where a customer may not be initially satisfied with the response they receive from a CSR, or they may have further question and it escalates to either one of our resolution specialists or a supervisor. So the table in OCC 329 is escalations. And then I believe, Mr. O'Brien, you can confirm in EOE 21, that is what we defined as complaints.
So complaints in EOE 21 are the complaints in the first group are the complaints coming in from our regulatory EOE, for example. Those are the total complaints there. We also have a column that calls out those that we consider justified, and that is where the customer first contacted Yankee Gas or Eversource and gave the company a chance to address the situation, and we may have failed, or the company may have objectively made an error. So those are ones that could have been prevented and were escalated to the EOE and thus sent over to the company. In the bottom next matrix, you're looking at complaints that are received through other channels. And those channels include letters that are going to our executives or complaints coming in through other sources, Better Business Bureau, where just the same, where those are complaints, and then those that could have been prevented or justified.
Okay, I think we had a little bit that got lost in translation in OCC 329 because what the interrogatory asked for was the number of complaints received directly from a customer. And I think based on the response you just gave me that the tables on page 2 are showing the escalations from those complaints. So I think what I'm looking for is just an update to 329 that shows the total number of complaints received from customers and the top 5 topics. If that makes sense.
You said 329, you're talking about EOE 21?
Nope, I'm talking about OCC 329.
So just to kind of paraphrase that back, you're looking for the number of complaints that came directly from customers and the top 5 reasons of those complaints.
Exactly, yes.
Okay.
So can we turn that, I guess that's slate file
11.
Thank you.
Okay, understood.
Okay, I'm really getting close to the end, and then Attorney Will can take over. Let's see, OCC 510 Attachment 1. That's an example of a customer bill. And I just want to make sure I understand it correctly. The example bill, it shows $16,000 due, which would be a little daunting to me if I received that bill. So I just want to, how are customers supposed to know the right amount they're supposed to pay?
So Ms. White, I think I'll share on the history. Similar to the electric customers, there's what's prior to the bill redesign for the electric side. Remember how the electric bill doesn't describe the payment plan, required monthly payment plan amount? So while this is accurate, that is the total amount they owe. It's not their, if they're on a payment plan, they get the letter that explains all of the items. So this one's similar to, there hasn't been a docket on the gas side to redesign the bill like there was on the electric side. So this is part of what we've proposed as included in the $2 to $2.5 million bill redesign, is also taking any payment plan amounts and using that as the top right-hand corner of the bill. But currently, they have not had the bill redesigned, so they'll still see that payment plan amount from the letter we send them or email, but they'll still see truly how much they owe here on the top right-hand corner of the bill.
Okay, thank you.
You're welcome.
And actually, this is probably a good segue into briefly talking about the low-income discount rate. And we had some discussions about that with authority staff. And I do realize there's another whole panel on the rate design. So if any of the questions that I'm about to ask are better directed to that panel, I think several of y'all are on that panel, but if they're better directed to that panel, please let me know. Do any other states in which you do business have a low-income discount rate for both electric and gas?
Yes, in Massachusetts we do, and in New Hampshire we don't have a gas company, but in Massachusetts we do. We have for electric and gas for each of our companies.
Okay.
Yep.
Let me take a step back. It might work just fine for Massachusetts, but just to clarify for New Hampshire, you're saying you don't own the gas company, but New Hampshire has a gas company, but they don't have a low-income discount rate? Or
I
don't know.
am unaware of what gas companies in New Hampshire do. I just meant that we only have an electric company up there. And so all of the Massachusetts utilities have both an electric discount rate and a gas discount rate. Both for both, it's a flat discount, and but the percent discount is different for each company. Yet National Grid is they just went through their rate case and they're about to implement the 5-tier that we just implemented in Connecticut, that's been implemented in New Hampshire for 2 decades or more.
Okay. And you said they're both, it's a flat, both the electric and the gas are flat.
Currently, but we have an active docket that I'm one of the co-leads for, with sponsoring with the DPU and the National Consumer Law Center to redesign the 5 tiers, similar to kind of what we've done in Connecticut, looking kind of at New Hampshire as well.
Okay. And maybe this still applies even with the flat rate, and definitely would apply with the 5 tiers that you said you're trying to redesign. Can you explain how the energy burden target works in situations where you have a low-income discount rate applied to multiple utilities. And I think we were briefly touching on it earlier in some of the things you said. So for instance, if we have go ahead, you seem to be understanding.
No, I know what this question is. So it's if for low-income customers, if they have a gas and electric account, how do you consider what the target should be? Only one of either the electricity or the gas would be their primary heating source. For the electric discount rate, there wasn't a different discount, but there's a different usage cap depending on their primary heating source. Massachusetts hasn't figured that out either right now. They're just starting to put the calculation that I believe OCC had recommended based on the New York model of the cap as the 2% cap as a percentage of total billed sales. And we've also been influential in getting the entire analysis for all the 7 utilities to always include the impact on the average monthly customer's bill to pay for the discount rate. So I think it's probably going to start around that 4% or 6%, or 2. Actually, they might be starting at 3%, 2 or 3% right now, but there's no way. I think the costs are going to come up. That's the next step of, just like we realized that in Connecticut. I think they're in the middle of that, but we haven't seen a utility be able to crack the nut on like, how do you figure out who's oil heating? And for many customers who get the split mini ductless systems, for example, they have electric heat, but they also primarily use it for their cooling. And so if you wanted to even differentiate based on primary heating source, currently the town's assessor's website is the primary source of record for that. But I don't, how often do customers update that? Is the permit that they use, like to get it installed, are there people who permit it for the towns? Are they required to verify that? So there's still no perfect answer. I think between Massachusetts, Connecticut, though, we're gonna iteratively figure it out. But Roger Colton remains a lead and active in his analysis, and he was in New Hampshire and Massachusetts, just like he was here as the EOE's witness. And Charlie Herrick, who is finally retiring, we're very sad about that, but he's been, that'll be in the months ahead.
Okay. And you had mentioned in the discussion before about the electric low-income discount rate. And just to clarify, that's gone from, here in Connecticut, it's gone from a 2-tier discount to a 5-tier discount. And you're about to implement the 5 tiers on June 9th?
On the electric side, we're going to implement the 5 tiers. I think we submitted an updated status yesterday. The earliest we're going to implement is Monday the 9th. In the status update that we gave yesterday, we just said we've hit some complexities that we haven't figured out. We got to work through first, and so if it might end up needing to be delayed. So the 3 challenges, Ms. White, are of the 200,000 total electric low-income customers, 3,000 solar customers are very complicated to get on and off a different tier, and we hadn't initially thought that we would be not allowing customers to stay on their tier for their entire 12 months. So first challenge is the solar customers. The second challenge is the July 1, when customers, the whole supplier choice, low-income customers, that you have to drop everybody, and that's still hyper manual and needs IT, data hammer stuff. And the last is regression testing around all of that, including like getting the new matching payment plan amount to calculate correctly into those tiers without breaking anything. So it's become, in the last 9 months, I think, more complicated. We're still trying, but the message, the feeling, sentiments I'm getting from the team and our user acceptance testing stats indicate that at this point it's probably going to push, but we said we'd give them till Friday end of day to make a go, no go.
Okay, so I think
It's coming soon.
Okay, a fair paraphrasing of what you just said is there. It's not easy, and we're trying to work through all the
Yes,
in the process.
much better said. Yes.
And so as a result, though, we don't have any data from the 5-tier lighter at this time either. Then obviously, because no one has it, you don't have it, and UI doesn't have it. So
For data as far as like the impact it would have. Yeah, I know we've had it for probably more than 2 decades in New Hampshire, even since we did the benchmarking, whatever that docket was in 2020. We did indicate that New Hampshire has the lowest arrears by far per customer as a percentage of revenue. They just have super healthy collections practices for a number of reasons that we are not allowed to do here. I do think that ending the MPP below budget payment amount and replacing that with the low income discount rate, that will have a massive beneficial, well, it'll have a beneficial impact on the top 25 or top 50 customers who've been really enjoying those benefits, yet racking up a huge past due balance under that current below budget payment option for years, and that will go away. I think I answered a question you didn't ask, so.
No, I think that actually led to my question about talking about the complexities and trying to figure all of those out in the system. So, yeah.
I think gas is easier than electric. There's no solar, there's no supplier choice, it's
But
just,
it would still have the MPP and the below budget.
Yeah.
That's is.
hopefully below
gas, right?
budget payment would go away when we implement the low income discount rate, but we didn't put that in here.
So if I understood your interrogatory's responses correctly, the cost is in the building of the IT building of the lighter. It's not in the, once you've built 5 tiers, changing the discount in the 5 tiers, kind of like with the electric side, the changing the discount isn't nearly as expensive as the building it that has the real cost.
I'd say 2 things. So once we build the 5 or 6, whatever we build, I think Massachusetts has statute that says they have to do a moderate income discount rate too. They haven't started a docket on that yet, but there's a statute. So in Connecticut, whatever we build, if we build it up front, even if we only use 2 of the 5 tiers, fine. But whatever we land on, that it made it way more complicated to not have a tier for, today we have a 10% discount and the future 5 don't have that. And that blows up our ability to do like a phased implementation, because then it's gone and we have to implement all 200,000 customers one weekend. So the transition is huge and we're ruining people's weekend in the summer and doing something that's kind of unprecedented. So I'd say that piece of it's complicated, meaning like whatever we want to go to for that structure, start there.
Okay. Last question for me. Did you send any correspondence or information to municipalities about this rate case or the low income discount rate?
Our colleague is here to answer.
Oh, great. Thank you. Good afternoon, Jeff Pugliese, Director of Community Relations for Eversource. We do send periodic correspondence to municipalities about low-income discount rate changes and a number of other things. I don't know. I'll have to get back to you if it's specific to this rate case. I can provide those details after the fact.
Okay, actually, we could just make it easy and turn it into an LFE. If you could provide us whatever information you sent to municipalities about this rate case and or about the low income discount rate that you're providing in this rate case.
Sure.
That would
Happy to
probably
do
be
that.
the easiest way to do it.
Yeah.
So that's LFE 12?
Correct, 12.
Thank you.
And I'm gonna suggest we take our afternoon break here. So it's just about 3:10, so we'll break in for 15 minutes, 3:25.
I do. Thank you very much. Very helpful.
Please be seated. All right, we can go back on the record. Attorneys Tisler or Pace, anything before we resume?
Yes, thank you. I believe our witness, Seamus O'Brien, can respond to read-ins A and B at this time.
Very good.
Okay, I will start with read-in A. There was a question about line items 21, 22, and 27. And I apologize, that was RRU 059. So in line item 21, that covers our contracts and vendors. Some of the costs were related to headsets for our team, just regular materials. We have one vendor that it's for Spanish translation. Our surveys are translated into Spanish for our customers who do not speak English or would prefer to answer in Spanish. We also translate some of our research to make sure in Spanish to make sure we're casting the net a little bit inclusive of that group. Some of our communities have a really high English isolation as it relates to Spanish. We also include in those costs our third-party phone vendors for our surveys. We, on some of our smaller samples or specialized research, we do our small sample transactions. We do use a phone vendor to do our surveys so that we can get a sample, a good enough sample. Emails are not insufficient there. It includes our online community vendor, where we do all of our testing on different topics, and then another vendor for Go-To Technologies. And Go-To Technologies was our webinar. However, we've discontinued that with the latest technology. We are able to, Teams has that capability. We are able to use Teams instead at no cost to do our webinars. Finally, under line item 22, those costs are specifically for our JD Power subscription. This allows us to get the data behind the results so that we can do our own analysis and slice and dice the data so that we can see, understand the different demographics and how they're performing and how we benchmark against our peers and where we need to improve any gaps. The MTAB vendor under that is the tool used. It kind of goes hand in hand with JD Power subscription. It should be a very small fee, but that's just a tool we use to pull the data and do the analytics. And then the last one, line item 27, that's actually credit. That was due to an on-voucher liability that was processed for our phone vendor that I mentioned under line item 21. So that was a one-time UVL that somehow was captured under that line item. Okay. Read in B, if I may. I'd like to reground us on some of what I brought up, and I'm going to say it a little bit differently. We survey enough customers to achieve a number of responses to be 95% statistically significant, which is generally accepted as statistically representative of a population. For a population of 100,000 and above, you typically need around 384 responses max to achieve that 95%. Our surveys are random, and we use a large enough sample to achieve these results within a period of time. For smaller populations, such as Yankee Gas, we look to be representative over a quarter, biannual, and annually. At the next level up, such as the state level, we look to be representative monthly. We avoid oversampling, which could lead to high opt-outs, survey fatigue, and may not result in a change of scores or any additional insights. With that said, we were asked about the numbers for our post-contact surveys. Our post-contact survey responses from customers who stated they have gas service with us are, in 2021, we received 2,105, well above that 384, which breaks down to about 526 per quarter on average. Still above the 384, so we are statistically significant, say that fast, at the quarter period. In 2022, we received 2,050 in Connecticut from gas customers who have gas service with us. That's an average of 513 per quarter. And in 2023, we received 1,883 at an annual level, which on average is 471 per quarter.
Thank you.
You're welcome, Martha.
Okay, Attorney Wheel, please.
Thank you, Tom Wheel for the Office of Consumer Counsel. My first question is a follow-up on Attorney White's question about OCC 25, and I think it might be for Ms. Peruta, but maybe it's a quick question. I'm not sure if she's actually in the room. I can give the question a shot, which is that the response to OCC 25 indicates that all the customer service plant is on the Eversource Energy books, and I think that was the response earlier today. So some of those costs are allocated to Yankee, is that correct?
Yes, you are correct.
Do you know where in the SFRs we could see that allocated cost, like which schedule? That would
Sure, absolutely. I believe off the top of my head, it is in C-3.32, but please let me double check in 1 second.
Sure.
Correct. It's C-3.32.
Okay. And one last question about that. When plant is allocated from Yankee, from Eversource to Yankee, is the cost that's allocated, like, is it structured the same way as revenues to support plants in regular Yankee rate base, meaning it's the cost, it's the return of and on the investment as well as like the tax impacts at the Eversource level?
That is correct. It is a full revenue requirement, correct.
Okay, thank you.
You're welcome.
I had some follow-up questions on Attorney White's cross on artificial intelligence. Mr. Lawrence, I think you referenced the importance of ring fencing customer information. Did you mean that the company is taking steps to ensure that customer information isn't like inadvertently shared with unauthorized recipients?
I would answer that, Attorney Wheel, by saying we've always been doing that, irrespective of our AI pilots. But specifically in the context of AI, we are constructing an internal, completely ring-fenced, proprietary large language model that would not allow information to flow outside of our virtual walls.
Thanks. I was just curious about what kind of customer information. I think Ms. Kane referenced personal identifying information as like a category. What kind of customer information does that include? What kind of customer information is necessary to protect in the company's view?
Well, we protect all customer information that isn't necessary. Well, we protect all customer information, period. We don't share anything externally with anyone except for vendors who are under NDAs and whatever other appropriate cybersecurity agreements are necessary to that. And that's only for them to conduct business on our behalf. Now, in the context of our AI Center of Excellence, if that's where you're going, Attorney Wheel, the large language model is populated, as I understand it, based on the needs of a specific business case. So until unless and until we are developing a specific pilot that has to do with, more effective research of specific customer attributes, we wouldn't necessarily put those attributes in the large language model.
Understood. Thank you. And are there, I think you were getting at this a minute ago, Mr. Lawrence, but are there protocols and policies generally for Yankee for the actual live CSRs and company employees to ensure that customer information isn't shared with unauthorized recipients?
Absolutely so, and it's part of their training, and I can defer to my colleagues here who could offer more details on that.
It's part of our code of business conduct, which all employees, including CSRs, are required to take. Mr. Bajan can speak to the third party, right? And Mr. Lawrence, it's part of their training. We limit access to information to people, only the people who need to know, right? So for example, PII, which Ms. Kane spoke about earlier with Attorney White, the social security numbers or IDs are redacted except for the last four, except for a handful of people and things of that nature.
Okay. I was going to ask about, go ahead.
May I supplement that? So in addition, our policy Y160 is customer confidentiality. So that really clarifies all of what we can and can't do. So for example, we personally identifiable information. So there's PII and NPI data, but PII is like your social security number. NPI would be like your account number. So it's non-public information. It's not personally identifiable, like if you found it in the world. Personally identifiable information will only be confirmed and not provided to a customer or their designee, for example. So this is just item 4 in our policies. We have very strict policies, and it's also why Eversource fought so hard not to have to accept email receipt of household income information because it has social security numbers on it, and anyone can hack into that. If we're advising, and I know that's happening in other places in Connecticut, it is highly hackable and not a good idea to do that. But so that's the policy that relates to and it lists the code of conduct in there as well.
Thanks. So at NPI, would like names, addresses, balances, would that fall under NPI?
Yes. So account number, balances, do you have a verified financial hardship? So it doesn't personally identify you, but it's non-public information.
Okay. Do you know what the policy is within Yankee or Eversource at large if NPI is inadvertently disclosed? Is there a policy for does the company have a policy about informing the customers whose information is disclosed?
Yes, there is. And I do not have it, but I know that we have I know we can take that as a late file, unless Vincent already knows it.
We can provide that as a late file exhibit to identify the process that we have.
Thank you.
I apologize. Is it the process or the letter? I didn't capture.
We'd be happy to take it in whatever format if there is a written policy, or if it would be easier for the company to provide just a narrative explaining the company's policy when NPI, non-public information, is inadvertently shared, the policy for customer communication with the affected customers.
Thank you. That's late file exhibit 13.
Thank you.
Mr. Wheel, Tom, if I can also just add, within that same customer service policy, we added endnotes for the statutes that are related to it. So you can also see just that we won't process that data for use of targeted advertising, sell it. So there's some good guidelines in there that that drive what we adhere to. Yep, that's it. Sorry.
Thank you. I have some questions I'm planning to ask the compensation and benefits panel about incentive compensation, but I wanted to try a couple on this panel because I think that this panel's knowledge specifically of customer service employees might be helpful, but if these are better for the comp and benefits panel, let me know. My understanding of the incentive compensation structure is that individual employees' incentive goals are set in accordance with their job function, like by their direct manager. So I was curious if this panel could identify any of those specific goals, like for customer service employees, like just as examples, like the kinds of incentive compensation goals that are set for customer service employees.
Okay, good afternoon, Attorney Wheel. So I will take from a CSR and call center supervisor perspective. Our approach is that we work to hold CSRs and supervisors accountable for things that they can control. So for incentive compensation for our CSRs, for example, we hold them accountable for things like discretionary average handle time. And I define that as hold time, i.e. the average number of seconds that they put a customer on hold, or after call work, the amount of time they take to close out a call after completing it when the customer is no longer on the phone. Their quality assurance performance is another example. We have something related to what we call emergency response. So in the event that there is an emergency event, a weather event, or an outage event, or some sort of major restoration event, we measure CSRs on how often they respond, and it's based on a percentage. And that's both in their performance reviews for mid-year and year-end, but also as part of our performance-based work from home program. And the supervisors have the same thing at the team level, right? So they're responsible not just for themselves, but for their entire team, and they're held accountable for that, as well as ensuring that they do all of their coaching and they listen to their quality assurance calls and score them, right, to ensure that our CSRs have all of the things necessary to do their jobs.
Thank you. And this is just a question. I'm going to pick discretionary average handle time just because I'm trying to get a sense of how these things are structured. Would that be like, is there like a target time, and time that exceeds that would result in a lower incentive compensation, and time that is less than that would result in a higher level of incentive compensation?
I'd be happy to answer that. So in essence, it's a 5-tier option, right? So it's based on 1, 2, 3, 4, or 5, right? 3 being essentially you achieved what we were looking for you to achieve. 4, you exceeded it, and 5, you essentially I would call crush it. And 2 means that they have work to do in order to get to be successful, and 1 means that they're not meeting it. And so we provide ranges for the CSRs on what those are. And so they know that, okay, for after call work, for example, because that's an easy one that's quantifiable. They know what the ranges are in terms of to be a quote unquote 1, 2, 3, 4, or 5. It's very quantitative.
Okay, so like for each one of those ranges, there would be like a certain number of minutes would equal a 3.
Correct. Yes. So for after call work, it's usually in seconds. I don't have it off the top of my head. I can get it, but
that's okay. I just wanted to understand that, like how that structure worked. Thank you. I was trying to get a sense of the kind of reporting hierarchy for the customer service related business area, and I was looking at OCC 77 attachment, the attachment on page 2. And there's no like gotcha at the end of these questions. I just literally am making sure I'm understanding how the exhibit works. On page 2 is Vice President Customer Operations, the same position as Vice President Customer Operations and Assistance Programs, which I think is Ms. Kane's title according to the testimony?
Yes.
Okay.
I was robbed a few words there, Tom.
And so is that a change? Like, is that a newer title that now it's just?
About 5 years ago, when we started really shifting this away from just operations and really helping from an energy affordability, low income discount rate, arrears forgiveness programs, and COVID in general, trying to, we did shift that. Customer operations didn't feel like it caught it, caught all of it. So assistance programs felt more representative.
Understood. What is, there's a position that reports to, it looks like that vice president position called manager operational execution for major projects. Is that related to customer service?
It is. This is my own Stephanie Tewksbury, Captain Tewksbury here. She is my right hand across projects and regulatory efforts, and all of our interrogatories and making sure we get things in on time and on quality and reviewed, but also a subject matter expert across like everything. And as a former captain, she is still my captain. I'm embarrassing her, but this role was excellent. It was invented, brought here by my boss, our chief customer officer, to help out with the big implementations of change, inclusive of like all the orders coming in as well. So that's there are no direct reports to that role, and we have Ashley is in a similar role for the contact centers.
No direct reports sounds awesome.
But everyone reports. Everyone reports well to them. Just there's no mid-year reviews for them. People.
I noticed that on page 6 of the same exhibit, the same title, manager operational execution for major projects, is shown under the director for contact centers. So is that the same person or is it just like the same? Okay, understood.
Same position. That's Ms. Canali, who's behind me.
Okay. Thank you. That was all my questions about that. All that jumped out at me was like that didn't, I wasn't sure whether that was even a customer service related role, but thank you. The testimony, the original testimony on pages 11 through 12 discusses the upgraded customer service policies, the updated customer service policies. And my understanding is that those updates were also submitted in docket 180510.
Sorry.
And would that be a motion that was filed? I just couldn't find that in that docket. Do you know if that was a motion filed in the docket or?
So first, Attorney Wheel, are you looking at page 10, like where it defines a policy? Is that?
I think.
Pre-filed testimony?
Yes, I'm looking at the pre-filed testimony. I think on page 11 through 12, it talks, the testimony goes through the updates to the policies and then explains that, I think my understanding is that the company has submitted those both as part of this rate case and then also for approval in that other docket. The question I'm driving at is just whether, since this testimony has been filed, whether PURA has already ruled on, like has approved these in another docket. That's my question.
So our understanding, I'll lean on our attorney's help on this one as well, but is that PURA's rule is, and I might have the wrong word there, is that within 30 days of, if you have any changes to policies, within 30 days of filing, that they become effective, whether or not the authority decides to rule on them. So 30 days after we filed these policies, they became effective.
Okay, thank you. I'm going to close with, I think, just a couple more questions about the low income discount rate. I wanted to thank you, Ms. Kane, for the update on the Massachusetts proceeding, and I wanted to say I hope you're telling our counterparts in the AG's office that all the best ideas you have came from OCC.
We will make sure we let them know that. We did tell them that they couldn't have got over the hump in Connecticut for data sharing without OCC. We probably offered you guys up as well.
Thank you. And Attorney White was getting at this, I think, but I just wanted to ask a couple questions just for clarity. So the testimony discusses scenario analyses for annual costs, and Ms. Kane, you've testified at length today about the multiple updates and scenarios that the company has performed. One of the general, and I think again, this was kind of alluded to with Attorney White, but one of the general concepts of a low income discount rate, like the aspirational concept, is that it's not only a more progressive rate structure that closer reflects household energy burdens, but also ideally that it can reduce costs of uncollectible debt and potentially arrearage forgiveness programs, correct?
I believe, Attorney Wheel, that we've been on record since the electric discount rate that it's super reasonable to believe that having lower bills must result in lower uncollectibles because there's lower bills. But as Roger Colton also testified, and Charlie Herrick at the National Consumer Law Center, nobody's been able to quantify that because you lose your control group as soon as you implement it. You can't implement it partially and over a long enough period of time. So it would feel unreasonable to think that having, someone who's getting a 50% discount on their bill today, that has to over time, who hasn't been paying their bill, because again, the majority of low-income customers do not have a past due balance. But for those who do, having a lower bill should result in a lower balance over time.
Thanks. And is it I'll start by saying it's certainly like OCC's hope and aspiration with respect to the low income discount rate for electric companies as discussed and redesigned in 171203 RE11 that will get to a place where enough time has passed that we'll be able to try to kind of get a look at whether it's having an impact, but know all along that we'll never actually be able to calculate it. Does the company feel that there will be after some amount of time, that it'll be helpful after some amount of time to evaluate the impact of the 5-tier electric rate on things like uncollectibles for CLMP?
We would love to. I think the challenge that we're going to have is I don't feel like there's any future, at least in the years ahead, that allows us to do the collections practices that we used to be able to do. And they were huge and meaningful. So and I know we filed last Friday, about a week early, our annual energy affordability assistance and arrears management plan. And in that, we included the same graphs as last year, but just updated, showing, we've had the discount rate in place for a year and a half. The electric arrears for financial hardship customers remains more than 2 times higher than it was pre-COVID. And for non-hardship, it's 3 times higher. So on page 3 and then we can attach it into this docket, but the annual affordability plan that we just filed Friday, we can put that on this record. But there are 6 things that need to happen to be able to compare it and actually start bringing down costs. So we need to, if it's helpful, I could just get this, I'll just walk through these. So similar, and we're trying to be super transparent. So whatever we're recommending in the annual arrears management and energy affordability plan. We use the same information if we're speaking to external stakeholders who are asking what else needs to be done to to make bills more affordable. We need to be able to do collections. When you hear about the script, currently we're always required to offer the lowest monthly payment amount first. So as a result, the outcome continues to be that customers are paying as little as possible despite what they can pay. So that's one of the items. If that doesn't change, we won't see the impact of a discount rate, right? Because just people are going to keep paying the least amount. Allowing customers to stay on payment plans for 2 months with no payments, and then allowing them to do it multiple times. And right after they disconnect, they can infinitely get on a payment plan still. There's about 100% reduction in down payment required to avoid a shutoff, a 50% reduced down payment to reconnect. Deposits for residential customers are no longer allowed. I think we gave back $20 million. That hugely reduced arrears because most customers who move in, most of those deposits were used to pay down their debt because they move again within 2 years, or those who've previously written off. And last is legal collections, which we know has restarted. We're allowed to restart based on PURA's most recent ruling in November, but not for customers who are low or moderate income customers. So it's going to be really hard. We kind of lost our baseline is basically it. We'd be completely hypothetical, but there has to be a way to figure out to quantify some benefit. I don't know what it is, and it doesn't feel like we've hit stability yet. But I would like to because I think other states could benefit from it as well. So.
Just a question for Attorney Wheel. The witness identified the key principles in the filing. Does that respond to his question, or would you want the underlying filing put into the record?
That I found the response responsive. Thank you. And I assume I know the answer to this next question because the company has proposed a LiDAR in this case. And for the record, the company wasn't ordered by Pura to propose a low-income discount rate.
Correct.
Does Yankee support the implementation of a low-income discount rate?
Yes, just like we did for electric, we started advocating for that in the fall of 2019. That was I stood at that podium and I said, we need two things, a discount rate and data matching. So we continue to be an advocate for having a discount rate.
Okay. And Yankee supports the incremental cost that would be associated with implementing a low-income discount rate?
We think that with we super value stakeholder input. If the cost per customer is too high, then it should be, bring it down. And that's why it's a little uncomfortable to do proceeding like that because we haven't had that collaborative opportunity that we did on the electric side to do iterations over years. We do think as well that one clear cost benefit would be elimination of that below budget payment for gas customers on MPP, just like we did with electric. We neglected to put that in our proposals, but I don't know how we add that now, but we know that that is valuable, and we did see that as we were looking at some of the top 25 customers who've accrued a past due balance over many years, yet have been making their monthly $25 payments because they've been on MPP, BBPs.
Thank you.
$50. Thank you, Dan. 25, that's a different thing.
My last questions are just about getting back to, there was some discussion earlier with Attorney White and earlier with the Pura staff, I think, about the estimated cost, the IT cost for implementing the rate as discussed in OCC 67. So that's an estimate of 2.5 million. I think I heard testimony today that the expectation is it's like a range of 2 to 2.5. Was that accurate?
That's correct. It's a range of 2 to 2.5.
And would all that be capitalized? Like, is any of that expense?
All of that would be capitalized.
Okay. And as this panel might be aware, the IT capital on the electric LiDAR is recovered through the SBC. Is the proposal that these capital costs be recovered through the EAC or in rate base, Ms. Peruta?
That is correct. So within the EAC rate, we requested low-income discount rate program costs and it's really the overall cost associated with the low-income discount rate. So our request for developing and implementing an EAC rate would also include the request to recover those costs, similar to what we did within the RAM filing and the SBC rate, correct?
Okay, understood. I did see that general concept. I just wanted to clarify that the capital costs of the IT are also proposed to be in there. Okay, thank you. That is OCC's final question for this panel.
Thank you. Let's proceed with the cross by the EOE, please.
We didn't plan out who would say hi first, so. I am Brittany Wyman. I'm an attorney for EOE, and I'm joined by my colleagues Frank Augeri and Athena, I don't, Viola, thank you. And Frank is going to start for us.
Hi, good afternoon. Frank Augeri, Authority staff. If we could, I'd like to start with the response to EOE 3. And along with it, attachment 1 from EOE 3. So there was some earlier discussion about benchmarks. I wanted to ask one clarifying question first. Is average speed of answer one of the performance benchmarks with your third-party vendor?
Just to clarify, when you say performance benchmark, we use that term to mean something that we compare with peers in the industry. Is that what you're talking about? Or are you talking about it in terms of a performance metric that we manage with the vendor?
Performance metric that you manage with the vendor.
Thank you for clarifying that. Let me just confirm momentarily. The answer is yes.
And a quick question on these statistics in the metrics in the attachment. Are the ASAs reported here only for calls transferred, or does it represent all calls made to the third-party vendor?
It would represent all calls to the third-party vendor.
Direct calls and transfers?
Yes, sir.
Okay. And specifically, are these statistics for Alorica only?
Apologies, we're just validating. Give us 1 second. Yes, the statistics are only for Alorica, correct.
Okay. So is there a goal, an average speed of answer goal that you would want Alorica to meet every month?
So average speed of answer is a metric that we manage kind of in the context of the overall customer experience. There is at certain call volumes, average speed of answer can be attained at a certain level, but at higher call volumes, especially if they're unexpected, it's not possible to staff cost effectively to maintain an average speed of answer. And so it's something that we have regular discussions on, but don't necessarily set targets per se. It's really the basis of an ongoing conversation between internally and with our vendor as to what's the appropriate staffing level given current and then forecasted call volumes.
So when we started our discussion here, you said that the average speed of answer, that's a benchmark, a performance benchmark for that vendor that you manage. Would it be spelled out? Would the ASA be spelled out?
I can consult for one moment, please. So it's a measure that we observe and manage daily with the vendor, but is not one of the performance metrics in the incentive and penalty structure that we talked about with the previous cross-examination.
Okay, thank you. So these statistics in the attachment for EOE 3 run from 2018 to 2024, and it covers entirely Alorica, correct? During that time period.
Sorry, correct.
Okay. The annual average, if we look at 2019, 2020, 2021, are below 90 seconds. Then we see a bit of a spike after 2022 and then 2023.
Was there any particular reason for the increase?
So I can take that. So 2019, that was our, I think the first full year with Alorica after the contract. But 2020 and then 2021, 2020 was basically the onset of COVID, where, I think around March of 2020, we stopped everything, sending out notices, everything. So the calls weren't coming in, and that's why the performance comes in lower. And as we progressed in terms of getting back to somewhat normalcy, that's where you see that the average speed of answer is kind of trending upwards.
Right.
Now, there are variable factors I want to add to that. Is with COVID, there are a lot of things that have become different in terms of projecting the call volume, in terms of what the average handle time is basically to get to that right amount of FTE that we need because of the multiple orders that we have to follow on the calls to make sure that everything is covered from end to end on every call before the customer is done. So I think that's finding the right mix. That's where you see 21 onwards, the average speed of answer trajectory kind of going up.
Okay. I believe earlier the authority talked about the increase in average speed of answer in the first 3 months of 2024. Looking at the numbers in attachment 1, after April, the ASA figures improved considerably. Do you know if there was something done specifically to help that?
I'll take that question. So I also want to kind of supplement what Mr. Bajan said, right? As we were beginning to do non-hardship disconnects, which I believe was end of 2021, early 2022, and then last year in May was the lifting of the hardship moratorium. We also experienced the effects of the Great Resignation, which impacted our vendor as well as internally. And so one of the recommendations in the management audit was, we had experienced a decrease in CSRs. In 2024, we essentially returned back to where we were Great Resignation, pre-COVID in terms of staffing numbers, in terms of being able to hire, and that also helped in terms of the average speed of answer post-April of last year.
Okay, thank you. EOE 4, please. I just want to get a clarification. Does the IVR system immediately recognize if a customer asks to speak with a live person?
Mr. Coco?
So apologies, sir. Could you repeat the question?
Certainly. In EOE 4, does the IVR recognize immediately if a customer asks for a customer service representative?
It does. So it goes through a script. It does recognize the response that it will provide to a customer. It's going to inquire what the customer is, the nature of the customer's business, so it can direct them to the right representative with the proper skill set.
I believe you talked about, or one of the panel talked about the system has a number of words that it uses to recognize a request for whether it's operator or representative.
Correct.
So the customer doesn't have to say a magic word to get to a customer service.
It does not. So we call those utterances, and it's able to recognize. And the system we use is state of the art. So we've gone through a lengthy process, Mr. McGrath and I, to identify an IVR vendor that provides those capabilities.
Okay.
And the system will attempt to assist the customer before routing to a CSR. But if the customer's ultimate desire is to speak with a CSR, they can speak with the CSR. To your point, Mr. Rogeri, there's no magic word, there's no specific phrase they have to utter. If they say speak with a CSR, I want to speak with somebody, that it will recognize all of those things.
Okay, but the IVR will still try to narrow down what the question, what the
Correct.
customer's issue is.
Right. We ultimately want to try to help the customer, because even if they need to speak with the CSR, sometimes they can self-serve themselves, or if they ultimately need to speak with the CSR, as we were discussing with Attorney Church earlier, we want to get them to the right CSR, right? So based on the skill, so that the IVR will be able to determine, oh, okay, that is a gas call, for example, a gas billing call, as compared to a gas customer who requires hardship protection.
Okay, thank you. And then just one last question on this interrogatory, page 5 of 6. In the response, there's a number of, we'll just call them scenarios. Would that 16 other inquiries be related to a person that just wants to speak with the customer service representative?
Sorry, just one moment. So, Mr. Ojeri, just I believe what we're referencing under other inquiries, and Mr. Lawrence addressed this, if the customer has a situation that doesn't come up very often, right? I'm trying to think of something off the top of my head, but something that there's not a specific queue for, and the IVR isn't able to understand what the customer is looking for, that is, I think, what we're referencing there under other inquiries.
Okay. So there isn't a specific entry for, I just want a customer service representative.
No.
But the system is automated enough that once it hears that request, it's going to act on it.
Right. It will attempt to authenticate them, and then to validate what it is they're looking for, will offer assistance, but will ultimately route to a CSR if that is what the customer is looking for.
Okay, thank you. EOE 10, please. Quick question on EOE 10, your list of walk-in payment locations. If that was printed out, how long is this? How many pages is this list?
This is Chris Kishimoto for the record. I believe that is a one-page insert front and back.
Okay. Is the list of walk-in payments, walk-in payment locations, is it ever provided as an insert with your bills?
No, it's included with our disconnect notices.
Disconnect notices only. Is the availability of the list ever made known via bill message or within a message on a bill insert?
No.
Has the company ever explored including the one-page list of payment locations as a annual insert?
Mr. Ojeri, I think we can answer that. We did create this list, and then we created additional fee-free locations within the communities that have the greatest low-income customer population. And we are required to include it in all of our disconnect notifications. The cost for a walk-in payment is pretty high. And so we don't, given that they can make a fee-free credit card payment right now, or pay for free via ACH or send a check, we don't encourage people to go to a walk-in payment location. If they're trying to avoid a disconnect, meaning it's time sensitive, then yes, and we do have it on our website. It's just, it isn't a channel that we're pushing, and it's also one that's declined in customer popularity significantly, even pre-COVID, but post-COVID as well. The walk-in payment locations are just not seeing the foot traffic that they used to.
Is there a lot of turnover in payment locations?
Not typically. We have seen some recently.
For example, the Western Union locations in Connecticut, I think due to a reduction in foot traffic over the last 5 years, they reduced the number of walk-in payment locations they have. Similarly, in New Hampshire, I think Hannaford's or something, one of the big grocery stores used to have walk-in payment locations, had a bunch of, and they stopped offering them up there. So I think we don't offer them ourselves. We partner with entities, but there are fewer and fewer walk-in payment location providers, period.
Quick question. So you said that the amount of payments made via walk-in payment location has been decreasing, correctly? I mean, correct?
Yes.
Okay. Do you keep statistics on the number of payments made in that method?
We do.
Is it possible just to get as a late filed exhibit, the number of payments made, say over the last 4 years at walk-in payment locations?
If you give me a moment, I believe we filed that data in one of our responses.
My apologies if you did.
49. Okay. It does, yep. So in OCC 022, we filed our walk-in volumes for 2023. And at that time, it was 2024 year to date up through September.
Okay, that makes it easier. Can we just get it as a late filed exhibit and update to April of 2025?
Sure.
Okay, that'd be great. This would be an update to OCC 22.
Thank you. And that will become late file exhibit 14.
And Attorney Augeri, we also, nope, Mr. Augeri, we right before you retire, you were going to be an attorney. We do in which what is it? I don't know what is it in a response, interrogatory response. Okay, we do already send it the payment walk-in payment locations as a bill insert to our gas customers at least once a year. From our website, it lists which inserts that we send each month, so we can see it on our website. Currently, it's not in an interrogatory response, but we do send it. We sent it in May of 20. We sent it this month.
Thank you.
Mhm.
EOE 11, please. Just a clarification on the response in section A. Does that exemption apply to a customer that has financial hardship during moratorium period? You do not refuse service to a customer?
That's correct.
Okay. EOE 15, please. Are there ever times that your termination notices are returned from the U.S. Post Office for unknown mailing address or incorrect mailing address?
Yes.
If a notice is returned, if the notice is returned by the post office, how soon would the company know about that? Or how soon would Kubra, your mail and print vendor, know about that?
So I'll bring my colleague up on returned mail, but in addition, I'll just offer, we are required to send our disconnect notifications via USPS mail letter. In addition, we opt all customers with an email address into receiving their disconnect notices via email as well. We have 90% of our customers' email addresses, so we can see when they opened it, when they received it, when they opened it. But we also send it via USPS mail letter. Do you want me to repeat the question?
Yeah, can you please repeat the question?
Sure. So you mail your termination notice first class mail, U.S. Post Office. If that's returned, how soon would you know it's returned from the post office?
So we would be dependent on the USPS, how long they take to return it to us. But my team goes in weekly and bundles up our return mail and sends it over to a vendor who researches those addresses to update them within our CIS system.
Okay. So when you have evidence that a termination notice was returned by the USPS. Are there any steps taken in regard to that termination to cancel the termination?
I don't believe we have any steps that would cancel the termination after we've mailed it to the mailing address that they have given us and sent them an email, so.
Your mail and print vendor, Kubra, do you know if they have a protocol, or is it the same protocol when they receive a termination notice that's been returned by the post office?
They do not receive the return mail. We receive it at Eversource.
Thank you. Thank you for that clarification. EOE 16, please. You were just talking about email and text messages on terminations. Do you have a protocol in place if that email or text message is returned for an incorrect address?
I don't have the information on the email. We could probably take that as a late file exhibit because I believe our digital director could help us on that. For text messages, we only, even though, so for text messages, we have customers opt in to that. So we don't, versus emails, we have them opt out. But for text message, if we get the wrong phone numbers, I'm not sure what the, like if the customer's phone number is terminated, if they got rid of the phone number, I'm not familiar with those processes.
I think we should take a late file for that.
We'll take a late file if you'd like.
Sure, but if you could, I'm just curious if there's any kind of notation made in the customer record that the next time they call you, there's a field that says, we don't have a match on either email or text, so your rep knows to query that question.
So I can answer that one slightly differently. So CSRs are required after they have authenticated the customer who they're speaking with to validate that the telephone number and email address are correct if we have one on file. If we don't have one on file, they are required to put one on file so that we have it. So that the next time the customer calls, we would, in theory, validate that and update that and confirm it.
Okay. I guess I'll just take the late file exhibit on what you do in the event of an incorrect email or text number then.
Slate file exhibit 15.
Okay, EOE 18, please. My questions on this are in regard to the attachments with EOE 18. I was curious, is the attachment attachment 1, is that the same notice that would be sent to a customer receiving a second consecutive estimated bill?
Just to clarify the question, are you, is the question, do we send this on the first estimated bill and the second estimated bill, or any subsequent, or is it just the first? So is that what the question is seeking to clarify?
Yeah, I'm seeking to clarify, is that the only notice sent, or is that sent for every estimated bill, whether it's the first or second or third, if there's more than 2 consecutive estimates?
I know that we send regular notifications for consecutive estimates, and that we also have processes for when we can't get access to try to reach the owner and get access. I'm not sure if this specific image with the dials about how they can estimate their own, or how they can read their own meter for us. I don't know if that attachment 1 is included in each one. I had assumed it was until you just asked the question. For each notification, we send them about their estimated usage.
Okay. Is it possible to update EOE 18 with any notice that's sent for any consecutively estimated bill?
If we could hold for a minute, I think we have a different interrogatory response about what we send to customers for consecutively estimated bills. Or we could read in if we find it.
Read-in would be fine.
We'll do that, okay,
Thank you.
for efficiency.
It'll be read in F.
Letters.
One question on the bill that was attached as attachment 2 in EOE 18.
Here's the bill.
On page 2 of the bill, in the bottom left-hand corner, the message center. Does the company have the ability to change the font size or add bolding or any other changes in text in that section?
And this would be the section titled Important Messages About Your Account.
Correct.
What's that? Oh, we have someone with the answer. Mr. O'Brien. Good job, Mike.
You're speaking of the message center on the bottom left-hand corner.
Correct.
Of the bill, yes. We have the ability to change the font and potentially make it bold. I will caution that when we do so, that takes up different space and that may limit our characters.
Understood. Understood. While we're talking about estimated bills, can we skip to EOE 31, please? The attachment 1 from EOE 31. Can you tell me what is the most common reason that one estimated bill is issued to a customer?
I don't have the specific answer about one. I can think of 2 scenarios, but I don't know that we have common cause analysis of the first. If we have a storm, if we have a major outage event and all of our crews are out focused on restoring power and doing our storm duty assignments, then we'll ask those bills. We won't have our typical meter readers will be out being wire guards, wires down guards or whatever. So that's one typical reason where it's a non-consecutively estimating meter. Another reason, so there's the metrology and then there's a communication module. So sometimes it's just that the communication module is getting spotty versus the actual metrology that reads the gas usage. So it can be an early sign of a meter's ERT or the communication module reaching end of life. So we do have processes around these that identify consecutive, because the first one can be an anomaly, but by the third, typically it's something that needs a meter investigation.
I was going to ask you, do you know what the most common reason that consecutively estimated bills are issued?
So the most common reason for an estimated meter? Is that the question? Consecutively estimated.
Consecutively estimated.
Typically, after first, I think we have very low estimated reads compared to the industry from a benchmarking perspective. So we know that that's very strong. We do know that during COVID, during those periods that we have reported in attachment 1, there were inventory issues across the nation, like getting physical meters into the country, for example. But the meters went typically after 6 months, it is either the communication module needs to be replaced or the actual meter. but they're two different things and I don't have the common cause analysis. I'd have to work with our gas operations partners to identify when they exchange the meter, how do they identify which pieces, which component is the root cause of the reading issue.
So you mentioned the numbers, just looking at 2024. So we look at the 12 plus month estimate. That's 243 customers or bills that have been consecutively estimated for that long. Is there any kind of specific program targeting those types of customers and eliminating those problems?
Yes, and I think we can work with our gas operations partners to talk more the specifics on that. But as we can see, the percentages improved after COVID because we know access issues uniquely with gas needing to get inside the premise and the customers making appointments. That's, it's annoying. Nobody wants to, be there for a gas meter or an electric meter exchange process. So. But we do know that that is what the process is to exchange the meters.
Just curious, do we believe the biggest issue for the consecutively estimated bills are meters that are located inside and scheduling access?
Yes, for resolving consecutively estimated meters, it's customers providing absolutely electric as well. It's getting access to exchange the meter. And for electric meters, it's much faster. For gas meters, it's a longer process.
Thank you. EOE 21, please.
Not us. Yes.
So the response in EOE 21 has a definition for justified complaint. Does the company have a definition for unjustified or non-justified complaint?
Yeah, thank you for that question. Essentially, the definition for a justified complaint would be a complaint in which the company first was given the opportunity to address the issue, and then we objectively made an error. So unjustified would have been either one of those criteria not being met.
Okay. Why is it a requirement that the customer make contact with the company first in order for it to be considered justified?
Because basic premise of customer service from an Eversource perspective is that if we're given the opportunity to make something right by a customer, we will do everything we can to make it right. If we're not given that opportunity, then we don't feel it was justified.
So are there ever any times that an error is made by the company that it's accidental, not objectively, there was a transaction between you and that customer and something was done incorrectly?
Absolutely, and that would be included in that definition. So objectively, we're not saying intent. What we're saying is that we made an error and then we were given the opportunity to address it, but failed to do so.
So objectively made an error could include any time that the customer service rep was acting on what they believe was the correct path, but it was not.
Yeah, correct. If it's not a matter of interpretation, then yes. That's what we mean by using the term objectively, is that there are a reasonable interpretation. There would not be multiple reasonable interpretations of the outcome in that situation. Objectively meant that there is essentially one reasonable interpretation, and we failed to meet that.
Want to clarify or ask for an example. If there's a call and a CSR explained to a customer that they had to go to a CAA in order to enroll on MPP, would that be considered an objectively incorrect or a mistake?
I could take that. So there are layers to that question. And let me unfold those layers for you. So the first answer is no, that's not incorrect. Because if the customer has no income, basically they have to go to the CAA And CAA can also assist the customer on multiple other things besides just getting on MPP. There's, SEEP, there's other help that we can provide to that customer on that. And if we are talking to the customer and we've just pre-qualified the customer for hardship, and we are giving them the information about MPP, how the program works, like a overall view, we always we can tell the customer, or the CSR says, like, once you've coded hardship, you can give us a call back. We can enroll you on matching payment program. But in old MPP days, we would have to advise the customer to go to CAA to apply for SEEP award, just to make sure that that award is kind of matched up on that. So that's
Okay, so with new MPP and the customer already enrolled as on hardship, but the CSR explained they had to go to a CAA, would that be
Can you restate your question again?
with new MPP?
Yes.
An MPP, so SEEP is not a requirement.
Yeah.
And the customer's already been enrolled and is verified hardship.
Yeah.
If a CSR then explains that they are required to go to a CAA in order to enroll an MPP, would that be considered an I forget the phrase, objective mistake, objective
Yeah, I mean,
error?
that will be considered like a coaching opportunity for the CSR to correct that.
Okay, so coaching opportunity is also the objective error.
Yes.
So I'll just clarify a little on that one. That's a good question because we know the innards of like old MPP and new MPP and what's SEEP is required. And we certainly know with the transition into new MPP in November, the decades old requirements of old MPP was still in some CSR's heads. And I think we got some questions around that transition period, which you might be kind of leading to. It's always best for the customer to go to a community action agency because we can't give them SEEP. However, they can enroll with us if they're eligible, if they haven't reached the limit. At times, it's the fastest to go in person and do both at once. Because for us, they'd have to upload their documents. Usually within 2 business days, we process the household income. But in the interim, in those 2 days, they can't sign up for MPP. Today, they can go to their local community action agency and sign it up. But to your explicit question on, is it accurate that they can only do it with a CAA? No, they could also do it with us. What's considered a justified complaint is different than what is an imperfect call. And so that's very important. So yes, they could do that, but that doesn't, would they complain about it? Is different. So a complaint is unsolicited. It's not a survey. It's not feedback. From a customer service perspective, a complaint is unsolicited. So it depends on if the customer complained and said, but if they did afterwards complain and say, hey, it's that next step, if that helps.
Yeah,
So-
helpful, thank you.
And if I can add just a little bit more context around this here is, when we're trying to define a justified complaints versus the other bucket, total complaints, is these are complaints that are escalated where the customer couldn't, like Jared said, could not get their issue resolved by just contacting the company or through regular means. This is where they had to reach out and escalate that to EOE or another formal process in which the company, again, they tried to work through the company and then they were unsuccessful.
Thank you.
Okay, one quick question. Does a customer's inability to contact the company count as a justified complaint? Say there's a situation, it was after hours, the customer could not reach you to remedy the situation.
I would say it kind of borders on the hypothetical because it would depend on the reason that the customer needed to contact us and whether we were the root cause of that in the first place. But I would say generally, no. The inability to reach us after hours would not be would not meet that criteria of having contacted the company first.
Okay. I'm going to ask for a late file exhibit on this interrogatory response. I just want to ask a question first. Is there a way to check to see if any response that was sent back to the EOE that our staff was provided incorrect information?
And could you be more specific in terms of, I know we submitted a number of interrogatories. Was there any specific question that Mr. Rogeri has a question about?
So the table one, let's focus on table one in the response, calendar year 2024. There were 104 total complaints. And in the course of EOE contacting the utility company, we'll submit a complaint and the company will get back to us. There may have been an instance where incorrect information was provided during the course of investigating that intake, that complaint. We're just want to know, is there a way to check to see if any response back to us in that complaint, informal investigation, where we were provided incorrect information?
Can I just pause and see if the witness panel, do you understand the question that's being asked of you, or do you want him to try and restate? I just want to start with that. Go ahead, Mr. O'Brien.
Thank you. And let me paraphrase to make sure I understand this. So what you're asking is, if when the complaint was sent by EOE to Eversource, are we able to go back and review if, based on our investigation, the data or the reasons for the failure or the cause of the complaint, any information we gave back was incorrect?
Correct.
Yep. I think we can take a late file on that. We have the ability to go back and look at the complaints and review to make sure that the information given back was accurate.
Okay.
Can I just ask a clarifying question, just in terms of, does the witness understand in terms of what the time frame is and what the scope is? I just want to make sure that we get that clear for the record before we conduct the research.
Thank you, Attorney Pace. If you're looking at 104, that is going to take us some time.
I mean, the other question we have too would be to try and help Mr. Rogeri get what he needs. If there's any particular subset out of that 104 that he has specific questions about, we're happy to look at those more carefully. If he believes that for some reason out of that 104, there's maybe whatever the number may be, if there are 5 or 6 that he wants us to focus on, that might be a way to timely get him the information he's looking for. So I'm just offering that as a potential solution.
We're just trying to get a reasonable sample size. So if we did one of the other years, 2020 had 74. Is that something you could do in a more reasonable timeframe? And for examples, we're looking for, if we received a customer complaint and we asked questions about their MPP payment, and we were told by Eversource an incorrect MPP monthly required payment. Things of that manner is what we're looking at.
Ms. Wyman, can I ask a question? What if, it sounds like this might be around that interpretation of complaint, a definition. And might it be that what you're seeking is like an additional column in this table that says, was this call imperfect, versus was that the cause of the complaint? Is that helpful?
More like, once we got involved, if we were provided incorrect information.
If EOE was provided incorrect information from us, not the customer.
Correct.
Oh, I don't know.
If I may, Attorney Wyman, when we investigate our executive complaint or regulatory complaints coming from the EOE, there's a lot of work that goes into that to make sure that we get it right and to make sure that we're giving you the right details and the full story, and to understand, even from our own perspective, where the process broke, and so that we can also apply our own HP methodologies in making sure we're focused on process improvements. With that said, that means we're going back on each of these and listening to calls again. We're pulling notes from our system. We are tracking timelines. So for each one, in a normal investigation, that could take I think we have an SLA of 5 days for each one. So we're repeating the process for each one that we're re-investigating.
The other concern I would add would be, again, we want to be cooperative, but what I just want to try and understand is I understand the question. For example, it's look at complaints that where EOE was involved. And during the course of our communications with them, whether it's through verbal or email or otherwise, was there some piece of information not correct? Did we give a wrong address? Did we say it was $85 instead of $81? That just seems to me a very fact-intensive, laborious review to see if there was some type of information communicated that was not 100% accurate. And so the first thing I'm trying to probe at is, what's the value? Should there be a materiality threshold? If there are small but not very relevant discrepancies, is that something that's probative that should be in the record versus are they looking for some type of materiality threshold? Out of those instances, were there situations where there was a discrepancy and it actually mattered, it was material? Because before we asked the company to now engage in this analysis, was there any piece of information you offered that ended up not being correct based on your assumptions? I'd like to see if we can maybe develop some parameters, maybe of materiality, to make it a more meaningful exercise and hopefully meet the requirement of being probative information that's relevant to adjudicating the issues they're trying to probe on. So is that helpful in terms of trying to maybe develop a more reasonable scope?
No, I do appreciate that. And I think what might be helpful too, because we aren't trying to do a labor intensive, useless LFE. And we have another sort of subpart we want from this. So why don't we go into that subpart and then maybe we can merge these things together. If you want to explain the rest.
Can I add one piece on this one? So, or two pieces. One is if there's not already a joint regular live review of this, those are so productive. I know Jonathan has the monthly meetings, but maybe on this, because we're not perfect, nobody's perfect, right? But the other challenge we are seeing, and through the Connecticut Legal Services provider, is as they're emailing questions back and forth, customer information changes throughout the day, like in every day. So the customer's required monthly payment amount today is different than tomorrow, depending on the tier and all that. So I think that becomes the timing makes a huge difference. But I think this feels like a, hey, get together, because it feels like there's a trust gap there that let's just go through it and get together more often. I think that would help no matter what.
I think what we're going to try to do is attack this in a different way. So the lay file exhibit, my request would be just focusing on 2024. The company indicated that there were 13 justified complaints. So the first part of it would be if the company could identify who the customers were in those 13 complaints. And recognizing that we're going to be talking about customer names, this would need to be filed protected so that if the redacted version could use numbers so that we could talk about those complaints in an open forum. And the second part of the complaint is what we're looking for is just for 2024, 24 complaints that the company considered non-justified. And this would be randomly selected, 2 a month, say one from the first 2 weeks of the month, the other from the last 2 weeks of the month. Yeah. Is that something that could be done? Is it more feasible than my first request?
I just want to say thank you for the offer, and can I have a witness respond in terms of, do you understand the request for Mr. Augeri, and do you feel that we can provide the information in late file 16 as he's proposing?
So on the 13, I think we can. And let me just make sure, validate, you said an example of 24, 2 a month, one at the beginning and one at the end of non-justified.
Correct. The 24 would be non-justified.
Correct.
Examples.
Okay. Yes.
And just to make sure, some sort of numbering system for all of them, just so if we have questions, we can do that more freely.
I typed that out. Got it.
That's late file exhibit 16.
Okay, late file, oh, excuse me, EOE 26, please. I noticed that the witness on this is Kevin Kelly. I don't know if anyone on the panel can answer my questions on this.
I think let's ask the question, and if we're not able to respond, if we could maybe, when he's back here, or we can have another witness available, or even consider a late file, depending on what the question is.
All right. Yeah. Do we expect Mr. Kelly to be here tomorrow?
Get us a moment.
Okay.
Thank you. It's our expectation he will be here tomorrow.
Okay. Would there be a witness available to answer questions on EOE 26 tomorrow?
And what Ms. Tisler reminded me is that if he's not going to be here tomorrow, he is appearing at a later date in the case for another panel. And so would that be acceptable to Mr. Augeri, that if he's not here tomorrow, we would make sure he's available to respond to your question about EOE 26?
Yes, that would be fine. Thank you.
Thank you for the accommodation. We appreciate it.
EOE 35, please. Oh. This question, the witness also listed as Kevin Kelly. I'm going to ask the panel. I think it's simple enough that the panel could answer it, but if they can't. Just curious, is there an absolute limit to the time that an after-hours appointment can be scheduled? Say, do you tell customers nothing later than 9 p.m. or nothing earlier than 6 a.m.?
Unfortunately, Mr. Augeri, the exceptions to the appointment schedule are made through gas operations. So that is something that Mr. Kelly or somebody in his organization would have to answer. I
Thank you.
apologize.
We can wait.
And Mr. Augeri, I was just informed that Mr. Kelly can be here tomorrow, so he was informed, and so we can produce him tomorrow to answer questions that you had on the earlier one, as well as EOE 35.
Right, that would be EOE 26 and EOE 35. All right, so my last question today is on EOE 39, please. So I'm looking at the bottom of the first page, the two bulleted statements regarding adjustments in budget billing. I'm then looking at the table on the second page, and it contains certain percentages based on the increases or decreases in a customer's usage at different review periods, say monthly, mid-year, or annually. My question is, are those percentages the actual percentages used for those two bulleted statements? Or are the percentages on page 2 of the response just examples?
Oh, it's dramatic. Those are the actual percentages used for the bullets on the first page for the usage increasing or decreasing.
And they would be the usage percentages and the actual time frame of the review period.
Yep, usage percentages is that first column, the time, or is the second column. The first column is the time frame, and then the last column is the nominal dollar amount as well. So,
okay, thank you.
You're welcome.
Good afternoon, Athena Fiola, EOE staff. Give me 1 second. So my first question will be with regards to EOE 8, specifically attachment 1. Does this attachment encompass both hardship and non-hardship customers?
Yes, it would include both.
Are you able to differentiate between the number of hardship and non-hardship?
Yes, I believe we can.
Would you be able to provide a breakdown that shows the number of hardship and non-hardship customers in each category for each of those months since the company's last rate case?
Yes, we can do that.
Okay, could we get that as a late file?
Be late file exhibit 17.
Going back to EOE 15. Is Kubra the company's only mail vendor that they use at this time? Okay. Thank you.
Oh, sure. Just for clarity there, Kubwa is our only vendor that prints and mails our bills. We do use another vendor, as I stated earlier, Redson, who processes our returned mail. Sorry, Chris Kishimoto.
Thank you.
Yes. Athena, one other point of clarity here. We do use another vendor for ad hoc mailings for letters that can't automatically get sent out of our system.
What's the name of that one?
And that is Hitchcock.
I believe all the vendor contracts were supplied in a response to an EOE interrogatory, and that one would be included.
I'd have to look. I don't recall. Yeah.
So I think it'd be read in, E?
Okay, read in G is so you want the interrogatory citation for.
The contract for.
Hitchcock.
Thank you.
Thank you for that. My next question is in regards to EOE 56. Under what circumstances can a customer receive a $25 MPP payment amount?
So, so this call occurred in January of 2024. So this was old MPP, just for clarity. In the old MPP program, it's based on the payment was based on your average bill over the course of a year, less any anticipated energy assistance. So if the customer had a low average monthly bill and the energy assistance, when included in that average, we would reduce it and then figure out what that average is with the energy assistance included, would or could bring the payment down to something lower than $50, in this case, $25.
So with this customer specifically, do you know what rate they were on at their previous residence?
Just give me a moment to find out.
Thank you. Could you also find the current rate they are on as well? Thank you.
If it's easier and for time, it being almost 5 o'clock, of reading our late file is okay on that. Oh, well, there you go.
So I'll start with the current rate. So they're currently on rate 2, the heating rate. And their old account was the same rate.
Being on EOE 56, this one will be with attachment 3. We are aware that we are the ones who asked about the $50 and below $50, but what does that mean to the company? Less than $50? Is that standardized? Is it anything under $50? How did you interpret that?
I'm sorry, can you repeat the question?
Yep. So with regards to $50, we asked everything less than $50. What does that mean to the company? Is that standardized? Is it $1, $2, $3? Is it 5, 10, 15, 20? How does the company interpret that?
It's anything less than $50. So it could be the $25 example we were talking about earlier. It could be less if a customer, if their average minus energy assistance, the anticipated energy assistance was less than that. Could be customers on a below budget worksheet at the $50 mark. So any of those examples.
Would you be able to provide a further breakdown with the number of customers on different required monthly payments, less than 50? So for example, you can set a threshold and do it by,
Like buckets, like 10 to 20.
yes,
30, yeah.
yes,
For all those years?
yes, please, since the last rate case.
Yep, we can do that.
And that would be,
Late file exhibit 18.
thank you. My next question is in regards to EOE 61. Is the company able to provide how many times this customer pre-qualified for hardship with dates from the time they open their account until their designation in May of 2024?
So how many times this customer pre-qualified for financial hardship from the start of the account to what date?
May of 2024, when the designation was put onto their account.
Yeah, we can provide that.
Okay, would you also be able to do that for the customer referenced in EOE 64?
Yes.
Is that late file 19?
It is.
Just want to confirm, Mr. Trainer, you understand what is being requested?
Yes, I
Right.
do.
Thank you.
I apologize. I'm not sure that I caught it. So, Ms. Viola, if you could please repeat
Yes, it's going to be the number of times the customer has pre-qualified for hardship
the customer that was referenced in EOE 64.
and EOE 61.
And if, well, you can make that. And if I may clarify, can you, I think for both, but at least for 64, if there was a hold, just make sure you put the dates and what the hold was placed on that account, if there was one.
Okay.
Thank you.
And my last question is in regards to EOE 92. Can you confirm the date that the customer service was disconnected?
I can take that. I'll just have to pull up the account to see when this was disconnected.
Thank you.
So this customer was disconnected on July 2nd, 2024.
Thank you. Are there any circumstances in which the company can accommodate a same-day reconnection? If so, what are they?
This question might be best for Kevin Kelly as well. I do know on the electric side, we did put in our last rate case, we did request the ability to do a same day, for customers to have the option to do a same day reconnect. That cost is over $100, but at least having the option, I don't believe we proposed that in this proceeding. And so same day reconnect, we could ask Kevin. Now, if it's a same day reconnect due to newly medically certified by one of the three medical professionals, my colleague can speak to that.
Yeah, so if a customer is off and they can claim medical for the first time if they've never done that before, and we'll go out and turn them back on same day. Or if they get certified for a medical condition by a doctor, an APRN or a PA, then we'll go out and turn them back on same day.
Depending on the time they call.
Yeah, depending on the time, during business hours.
Thank you. Those are all my questions.
Okay, we're gonna break here for the evening. Attorney Wyman, you have questions. Could you, I assume based on
I do, and you actually beat me to the punch. I was gonna ask you if you wanted to break. I believe I have over 30 minutes. I don't think I'm gonna make an hour.
Okay, so under an hour left for EOE cross.
I'd argue that'd be about right, especially with some of them being taken out for Mr. Kelly.
Okay, who will be here in the morning?
We'll be here in the morning, so.
Okay.
Yes, we can produce them tomorrow.
Okay, very good. Thank you. Then let's adjourn for